Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. Oh my goodness, I look like a disaster. Anyway, how's it going, guys? How is everything for you? We have some stuff to cover tonight. We have some things to cover tonight. You guys are trying to kill me. I already see it in the chat. Drink. You're trying to have me die. I don't know what I did. Why did I do this? Why am I the one who has to suffer? Sitting here thinking I'm just gonna drink like some dancing monkey for you guys, which of course I'm going to. I've got this green spot. Single pot still Irish whiskey. Where's the focus point? I can't find it. It's somewhere over here. Green spot. So that's I had yellow spot. Yellow spot is the more expensive green spot. It's about $30 more a bottle. And it's really, really good. Oh my God. I'm going to stop laying down right before coming on the show or like take a minute to do my hair, but then I'd be even later. Yeah, green spot is the less expensive to yellow spot. It's an Irish whiskey. We'll see how good it is. I have no idea. Tonight we have some meme law to cover, so to speak. We've got some memery, some law tomfoolery from Russell Greer. Two different things from Russell Greer. One of them I need to try and find real quick. Let's see if we can do it. Russell Greer. I did not cover these documents. We may take a peek at them, but it's a lot. It's a lot of stuff. But Russell Greer asked for the judge to reconsider throwing out his case against Josh Moon and Kiwi Farms. Okay. He decided that he would try again because he had such success the first time that he thought, I'll do it again. So he asked the judge to reconsider, and the judge, well, we won't spoil it. The judge has responded to Russell Greer's request to reconsider. Long story short. But Russell Greer has also, I believe, sued someone else. Here it is. Just on October 15th, this is a new case. A new case. Russell Greer has also sued for $800,000. Let's see. What do we have? What has happened here? Do we not have any documents? No. What is this? 72 pages. Russell Greer is suing America's Got Talent for $800,000 for discrimination under the Americans with Disability Act. Oh, that is, if you don't know, Russell Greer has auditioned for America's Got Talent. He has done this before. The video is out there. We might have to procure that video. Because, you gotta see what's going on with that. Anyway, so yeah, Russell's amazing. He sued America's Got Talent. We've gotten a response in what the hell? We have gotten a response in the Kiwi Farms case. So those are two big news items from Russell Greer. The other things we have tonight, sorry, I'm trying not to be distracted. The other things we have tonight are Melinda's lovely husband, Marshall, who was kind of a badass when he was younger, that his friends would call him martial law. He has also dropped some video responses to me as well. Of course, we watched Melinda's video response yesterday. Marshall has responded himself as well to at least two videos. And so we're going to definitely have some ideas of things we'll have to review Marshall's content, because the last time Marshall made a video, I was floored. It was one of the funniest things I've borne witness to. So we've got that. And then we may get around to checking out the ultimate LoLcow lawyer in chief, who is Merrick Garland, Attorney General of the United States, appointed by the Supreme Memesmith, Joseph Biden, author of so many memes these days, like this one. Like that meme. Yes. He has appointed a memeified character in Merrick Garland. And apparently Merrick Garland endured a little bit of a roasting as he testified before the Senate today. So we might get around to watching some Merrick Garland stuff. What's going on coming up? We have the Rittenhouse trial starting next week, November 1st. Trial jury selection kicks off, I believe. The motion hearing we just covered was the last pre-trial motion hearing, as far as I'm aware. There's still an outstanding motion to dismiss on the well, sort of. There's an outstanding motion to reconsider the motion to dismiss on the failure to dismiss the carrying a gun illegally while a minor charge, right? They have tried to get that particular charge dismissed because under the law, Kyle is not guilty. The law was not intended, in my opinion, by my read of it, the law was not intended to preclude an 18-year-old from carrying a 17-year-old from carrying a long barrel rifle or a long barreled shotgun. It would only be unlawful if they were engaged in hunting and had not completed the requisite hunting requirements to have a valid hunting license. That would then be an extra charge that they could tack on. That's the way I read the law as a defense attorney. Other people may read it differently. That's fine. I don't really care how they read it unless they have some good specific reasoning to read it differently, remembering that as a defense attorney and as a defendant, the law has to be written to prove beyond any reasonable doubt that you violated it. And there's a rule called the rule of lenity, which would suggest that if there is a reasonable interpretation that the defendant can use, that they get that interpretation, but or something akin to that. But yeah, so we need to see what happens with that. But since that trial is coming up, I may do either a short video, might not be that short, video of everything you need to know about the Kyle Rittenhouse trial before it starts, just to kind of cover what things they've already disposed of prior to the trial, because that's a different thing in how law works practically in a courtroom and how law works when we're outside of a courtroom, right? When you're outside of a courtroom, you get to You get to him and haw about a whole bunch of stuff. You get to say things in the court of public opinion. You get to be an absolute moron like George Takei, for example, and you get to sort of color the characterization of the case in a particular way. Once you get into a courtroom and you're bound by rulings and what can be brought, that's going to help us kind of navigate and keep some things in mind as we go through the trial. For example, what are the experts, right? What experts are out there to testify? John Black being the only expert. The Bob was withdrawn. Robert Willis or whatever his name was. He was withdrawn. He will not be testifying, most likely. There's an outside possibility that he could. What types of things can we say about the client, about the defendant, about the deceased, all these things that have been covered by pretrial motions, what's going to happen, what can be brought in. Just a recap for people in case they missed that. However, I'm also trying to line up, if I can, a particular live stream. And if that is able to be done, I'll do it that way instead. But it'll either be a live stream or probably a decent length, not live video about Kyle Rittenhouse is coming in the next couple days. And then I have stated I am going to try to cover the entire trial of Kyle Rittenhouse. I have to look at the schedule and see how to do that. I don't know. It might mean that my life is very terrible for the next couple weeks because my sleep schedule will be destroyed and demolished. But that is potentially coming. So look for that if you are a daytime person who's alive when normal people are alive and not a degenerate like me. The stream will likely be starting around 8 a.m. Excuse me. And we will be trying to watch the entire thing. I wanted to do this with the Chauvin trial, but I had an unfortunately timed trip to Florida, which didn't make that possible. But I don't have an unfortunately timed trip to Florida now. So we'll figure it out. It's not an empty promise, Sheila. It's not a promise. It's an intent. I have an intent to do this because I want to do this. I want to cover the trial thoroughly and give people an insight into it. And I like the live trial thing because it doesn't, I mean, if it's a 4-hour hearing or day, or well, like a 6 to 8 hour day, most likely on some of these things, that's how long it'll be. There won't be a pause, right? There's no pause opportunity. We'll just be watching along. Attorney Tom. I'm gonna put it out there. Attorney Tom, if you receive some flowers that look like cyanide pills, they're flowers and they're safe to sniff and eat. It's weird. It's a new breed of flowers. If you get one, it's from me. Maybe, I don't know. Might say an anonymous, say, hey, boo, or whatever. It's fine. It's fine. How's it going, buddy? How's it going, buddy? I've got something for you. I never forget. A slight on the internet. Not a single one. I remember every slight I've ever received forever from anybody in the history of the world, Tom. And I remember you. Okay. Next. Final thing before we get started here. I just invented a new food. A new recipe tonight. I had to make a quick meal for me and Lady Rackets, and it was really tasty. So I call it Beat the Brakes Off of You Instant Stew, and I made it in honor of my friend Yellow Flash. So we'll probably do a locals recipe for it in the very near future. It's really easy to make, and it turns out really delicious. So Beat the brakes off you. Instant stew coming soon on locals. If I make it to the store tomorrow, I may do it tomorrow. We'll see. There's no whiskey in it, but there is brandy in it. But the recipe is really easy. The brandy's unnecessary, but it adds some richness. Yeah, something people can make quick and simply, and yeah, it's good. It's good. Okay, I need this. I need this video of Russell Greer, America's Got Talent. Because it's too good. Oh, it's not that one. Shit. If anybody has the Russell Greer America's Got Talent audition, I think it's on Kiwi Farms. If anybody has a link to that, if they could DM me and just let me know, just tag me and say where you DM me, Twitter or Discord or something, because I know it's out there. I just can't find it very quickly. But first, what we're going to do is take a look at this order on Russell Greer's motion. And maybe just as what the hell is this? Here we go. Save that. Guys, I wish I could express to you how many lawsuits Russell Greer has filed. Actually, I'll just show you. We'll show you. Now, you guys are normal people relatively. How many lawsuits have you been plaintiffs in? How many federal lawsuits have you been a plaintiff in your life? That's the trick. Russell Greer has been a federal plaintiff in 1, 2, 3, 4, 5, 6 federal lawsuits. Oh wait, no, sorry, 5 federal lawsuits. Just quite a few. Very embarrassing. Okay, let me pull this up real quick. So we've got. Oh my God, he's. Hold on. Here we go. One thing at a time. Russell is something special. This world does not deserve Russell Greer. Let me do. Yeah, let's do it this way because I can. Whoa. Hold on. I'm just getting this to the right size, which is what I tell all the ladies. All right. So this is Russell Greer's motion. Motion to alter and amend the order and judgment and to reopen the case. Okay. So pursuant to Federal Rules of Civil Procedure 59E. Oh my gosh, I forgot. There's an initial chat here from the denialist. It says, oh boy, more news about the slime ball with the paralyzed face. A tip for Nick for such interesting content. Thanks. You are welcome. Thank you, Ken. All right, we've got the America's Got Talent video. We'll hit it when we get to that subject. First, we're on Russell Greer suing Joshua Moon and the Kiwi Farms. If you don't remember, he sued them for defamation because they said victims when he totally only had one victim, and she wasn't even a victim anyway, even though he was convicted of criminal conduct around her. This is not like Kyle Rittenhouse, who has not been convicted. This was after he was convicted of criminal behavior regarding this person who may even have a restraining order against him. I don't even remember at this point. But his argument was he only had one victim, and that's not really fair. And then some statements about him refusing to submit himself to a mental examination or a psychiatric examination, stuff like that. That's the basis of where this lawsuit starts. Trump Willis is my name says, hey Nick, so how do you shoot women and children? You just don't lead them as much. Best movie quote joke ever. Oh, because they're slower. I got it. What is that from? Yes, Warhawk of Chagoras, Joshua of the soft ass eyes. Oh God. Oh, and there's all sorts of weird stuff going on with the Alec Baldwin case. Full Metal Jacket. Full Metal Jacket. I've never seen all of Full Metal Jacket. I need to. There's a whole bunch of stuff going on in the Alec Baldwin shooting a woman incident. Turns out the county is possibly filing criminal charges. They didn't say against who. I don't think it's Alec Baldwin necessarily, but maybe the armorer for some sort of criminal negligence or something like that, or the assistant who was supposed to check the gun and didn't, all this stuff, and sat there and told the cops, just fessed up to the cops everything that he did. So we'll see if someone gets charged, but if anyone gets charged right now, I would say it's probably the person who sat and talked to the police about how he didn't do his job and didn't check to see if there were actually bullets in the gun. Good job. Good job. So, okay. Here we go. Pursuant to Federal Rules of Civil Procedure 59E, plaintiff files a timely motion to amend order and judgment and to reopen the case. In support of this motion, plaintiff relies on the facts and information below. The court's decision was respectfully based on clear error of fact. For this reason, plaintiff respectfully requests that this motion be granted and that the court's order and judgment of September 21st be vacated, the case be reopened, and the accompanying motion for leave to file amended complaint be granted. So the clear error of fact is a problem here because the facts in a motion to dismiss are based entirely on what the plaintiff claims. In fact, the court has to accept all those facts as true. So say, okay, everything you said, that's cool. You don't win. That's how it goes. Even if everything you said, Russell Greer, was true, you don't win the case. That was the ruling. That is a 12B6 dismissal. Is even if we take everything you say as true, you lose. So we're not going to bother. That's the idea. Because ultimately a trial is to determine the facts. Once the facts are there, it's the judge who applies the law to the facts. So if you have a jury, they are a fact finder. They are not a law decider. That's kind of a weird thing because jury nullification makes them a law decider in some ways. And that's probably why courts really hate it. But the idea of a jury is that they are to find the facts that actually occurred. One side has their version of facts. The other side has their version of facts. Those material facts being contested are where the law will hinge. So in this case, if all the facts are as you say, and the other side says, we have no problem for the purposes of this motion with the facts alleged, we want it dismissed. The court says, okay, all of those facts are now true for the purpose of this motion. And when we look at that, they say, oh yeah, the court has no business here because there's no lawsuit. The judge then applies the law. And that is how it happens with a jury trial as well. The jury says, these are the facts that we have determined to be true. These facts that are critical to the ultimate conclusion of law. And then the judge applies those facts to the law to do it. And they do it through jury instructions and all of that stuff, but it's the same process. This is one of the reasons that I don't like anti-SLAPP statutes, because they're a big difference between a motion to dismiss. Anti-SLAPP statutes do not take all facts alleged as true. They don't do it. They don't do it the same way. They take all facts that are alleged in a specific way under some specific extra category as true, but they don't take all facts alleged as true. So it's a subtle difference, but it's annoying. All right, so Rule 59E was adopted to clarify that the district court possesses the power to rectify its own mistakes in the period immediately following the entry of judgment. So again, just the idea of this is funny already, because the idea is that he's telling the district court, you made a mistake, you're wrong, and now you need to fix it. Rule 59E motion may be granted to correct manifest error of law or fact, or to consider newly discovered evidence. In order to show clear error or manifest injustice, the movement must base its motion on arguments that were previously raised but were overlooked by the court. Points of fact and law overlooked and misapprehended by the court. So here is where he's going to lay out his case. The court overlooked and misapprehended the following material facts in the law supporting the facts. Plaintiff did indeed cite inducement in his complaint. The case was not futile to allow plaintiff the chance to amend his complaint. Those aren't. We'll have to look at the inducement thing, but the case was not futile to allow plaintiff the chance to amend his complaint is not a fact that's contemplated by this motion. Again, they say there are very good paralegals out there, but paralegals like Russell and Melinda who believe they know what's going, they don't. They don't automatically. The paralegals that are out there that are very good are people who work really hard, and they tend to get a lot of experience in a particular area of law, and to the point where they can pick up some of the standard legal arguments and citations and understand what's going on. That's experience working through them. Russell doesn't seem to have any of that. All right. From the get-go, plaintiff stated contributory copyright infringement was his strongest argument because the CDA did not protect defendant in that regard. Greer ensured before filing that all three factors were met. His complaint was proofread by lawyers. Sure it was, Russell. Just like when you sued Taylor Swift and your magical super lawyer was helping you out until he got firebombed by Mexicans from the Mexican mafia that drive around El Camino shaped BMWs or whatever. That I'm sure that really happened. However, the court wrote in the judgment of 9/21/21 that Greer had sufficiently alleged prongs 1 and 2 of contributory copyright infringement. What is missing is the defendant's intentionally causing, inducing, or materially contributing to the infringement. It is not enough for contributory liability for a defendant to have merely permitted the infringing material to remain on the website without having induced or encouraged the initial infringement. Plaintiff kindly points out that the court overlooked that plaintiff stated the facts that defendant induced infringement as incorporated with paragraphs 1 to 113. Is he going to lay that out? I'm curious if he's going to actually lay it out, but here's the problem that we've got going so far. Saying that he induced infringement is not a fact statement. That's a legal conclusion. So that doesn't mean he actually did, but let's see what he says. The court overlooked the fact that plaintiff did indeed properly plead inducement by explaining in paragraph 111 that Moon is materially contributing to the infringement by running and managing a website that allows users to steal and dump everything about Greer. That's not inducement. That's the opposite of what they just said. Why? I want a refresher to right here. It is not enough for contributory liability for a defendant to have merely permitted the infringing material to remain on the website. So then he says, Moon is materially contributing to the infringement by running and managing a website that allows. A synonym of allows is permitted, Russell. Permitted and allows are synonymous. Merely permitting is not inducing. It's right above you. Moon has even defended such action on the website's frequently asked questions page. The facts page regarding copyrights was explained in paragraph 64 of Greer's complaint when Greer quoted the page. We do not host well-known copyrighted content. What copyrighted content we do host is usually covered under fair use. This would count as inducement. No, because it encourages infringement on non-famous works under the misguided claim of fair use. No, it doesn't. And so Moon's users would feel and know that they can infringe on works because of fair use. No, Russ, most people who post something on Kiwi Farms are criticizing the ever-loving shit out of it, which is why most of it falls under fair use. Defendants never argued fair use in their motions. They didn't have to. They didn't post the content, Russ. In Greer's fair use arguments, Greer showed Moon was allowing and fostering inducing infringement for purposes of criticism. Ah! Ah! Why? Why is Russell? Why? Criticism is a quintessential element of transformative nature under a fair use analysis. It's the most important criticism, parody, commentary. He's destroying his own arguments. Greer elaborated on the frequently asked questions in his opposition to defendant's motion to dismiss on page 6 through 8. In document 26, plaintiff expounds upon his arguments at his complaint and showed in doc 26 that in his complaint, the defendants did indeed induce. Greer put forth two legal theories on pages 6 and 7. The Ninth Circuit not requiring inducement, but you're not in the Ninth Circuit, Russ. And then he showed that he did or wait, is Utah? Is Utah in the Ninth Circuit? Let me see. Circuit map of the United States. Nope. Utah's not in the Ninth Circuit. It's not there. So that doesn't help you. And then he showed that he did claim inducement in his complaint per the 10th Circuit. It appears that the court made a note on page 5 of her opinion and judgment regarding the 10th Circuit not having ruled on inducement not being required. But once again, the court did not address the frequently asked questions that Greer expounds upon on the defendant's inducement and encouragement in document 26. When he shows that Moon did indeed induce, writing, quote, on Moon's site, frequently asked questions, he says that non-famous works will remain on his site under fair use. Yes, if it's fair use. One could easily turn to Moon's frequently asked questions and feel that they are allowed to upload to his site because Greer or any other LoLcow isn't famous. That's not inducement. That's not how Attorney Tom says, imagine not knowing if Utah was in the Ninth Circuit off the top of your head. See, someone reading Attorney Tom's statement there might be induced to buy a plane ticket down to Houston, Texas, and go to Attorney Tom's argument and punch him right in the nuts because he said that. So therefore, Attorney Tom has induced me to fly to Texas and punch him in the nuts. And I'll find a chick to step on him while he's there to make up for it. But okay. DMCA inducements infringe facts. Inducement infringement facts. The other examples and facts of defendant's inducement that the court briefly mentioned but seemed to overlook the full context of was explained on paragraph 67 when defendant posted the DMCA notice on his section entitled "Take That Off the Goddamn Internet." Greer explained how that section is meant to mock those who send sincere legal requests to have their works removed. Yes. Greer elaborated on this in Doc 26 by writing, further, defendants encourage infringement by showcasing the frivolous legal threats they receive. That doesn't encourage infringement. And thus, such a showing would inspire infringement as shown because the users would feel that they can get away with infringing. Nope. It's, again, not how it works. In fact, stuff has been successfully DMCA'd off of Kiwi Farms when the DMCA request is valid. I think. Maybe I'm wrong on that. I don't know. I don't know if there are any legal expert Kiwis in the chat, but I'm pretty sure some stuff has been removed through a valid DMCA request. But maybe I'm wrong. Maybe Josh has just said, no, sue me. Let's see if you win. Because that is one thing. But if Josh doesn't comply with a valid DMCA, he runs the risk of that happening. Coatam says it has happened. I think so. I seem to remember it happening on multiple occasions, but I don't know so. So that's why I was asking. Thank you for clarifying. He normally does say "fuck you." Yeah, he usually does because usually the requests are bogus, and that's by doing that, that's not contributory copyright infringement, but it could potentially put him at use for violating the DMCA. All right, here we go. Per Greer's complaint, Moon posting the DMCA on the section indeed induced infringement because users shortly afterwards messaged plaintiff laughing at him and mocking his music and saying they had spread the song elsewhere. Elsewhere. That's not. By the way, they're mocking your music. They're criticizing the music. It's criticism. But they're also posting it elsewhere, which is not there. Constructive design inducement facts. Lastly, as explained in the facts of the complaint, the very nature of Moon's site is meant to document and collect the actions and works of those defendants deemed to be weird. This is why Kiwi Farms has obtained the recognition of being the web's biggest community of stalkers, as dubbed by the New Yorker. This recognition isn't based off his users per se. It's based off of Joshua Moon himself and his actions of allowing all forms of harassment until someone takes their own lives, and then B quietly shuts down the thread of the person as a form of damage control. I don't think so. The people who off themselves, their pages stay up. But I like how the biggest community of stalkers isn't based off of the users, but just Josh Moon himself, which means the New Yorker and Russell Greer together just dominated soft ass eyes Joshua Moon by calling him the fattest motherfucker on the planet. The fattest fucking stalker you could find is Joshua Moon. They said it. That's how it goes. They just called him because that's the only way he could be the biggest community of stalkers all by himself is if he's just a big fatso. Organized Arizona Politics says, according to Barnes, Kyle's attorney is declining to use Barnes' super team of jury selection experts and is going to solo it. How do we blast him in public to get him to reconsider this idiotic decision? That's interesting. I don't know if blasting them in public is the right move, but that's interesting. We'll have to see. Anybody who ends up on the site gets bullied until they take their lives. Anybody, guys. Anybody who ends up on Kiwi Farms gets bullied until they seppuku. All of them. With anybody does. Anybody who gets on there. It becomes open season upon the unfortunate people who get put on that site. In the same frequently asked questions as elaborated on the opposed motion, Moon rarely ever removes anything about a person, and so it would induce infringement because the infringers know they can get away with infringing. That's not how that works. This is completely in line with case law that both court and plaintiff cited, but that the court respectfully misapplied. Russell Greer is the principal Skinner meme. No, it's the courts who are wrong. Oh my God. The sheer nature of Mr. Moon's stated website's purpose and his frequently asked questions pertaining to copyrights would induce anybody with ill intentions to infringe. Kiwi Farms attracts users of a mind to infringe. And then that's Kiwi Farms then, quote, attracts users of a mind to infringe, covering it or citing a different lawsuit. Respectfully, the court overlooked these facts that were in his complaint. Greer's complaint stated fully a claim for contributory copyright infringement. No. Russell, what they did was they looked at your facts about inducement and they concluded that those facts don't amount to inducement. And they concluded that correctly. Oh my gosh. All right. The court overlooked controlling and guiding law where courts look to whether a defendant. Don't get green spot. Don't get it. Yellow spot is much better. Much better. Ugh. Just not great. Sorry. The court overlooked controlling and guiding law where courts look to whether a defendant took active steps or affirmative steps to induce, promote, foster, encourage, stimulate, bring about, or cause copyright infringement. Even though the court quotes Grokster, there seems to be an error of law with applying the full guidance of Grokster. Based on that, finding inducement doesn't require the word inducement to be written in a pleading. Rather, inducement is gathered by the acts and intentions of the defendants, which Greer clearly explained Moon's acts and intent in paragraphs 1 to 113 that incorporated his copyright infringement claim. Yeah, that's what I said, Russ. They looked at the facts and decided that you didn't actually make an inducement case. To plead each and every fact and point of a cause of action is referred to as code pleading. However, code pleading is not a requirement in a case. Citing the Seventh Circuit, says calling the district court's reliance on code pleading problematic. Instead, the complaint need only contain factual allegations that give the defendant fair notice of the claim for relief and show the claim has substantive plausibility. Plaintiff stated many of the facts of his complaint simply, concisely, and directly that entitled him to contributory copyright infringement relief without needing to specifically use the word inducement. He's focusing on the use of the word and not the fact that his facts are weak. How many DSPs was this bottle? It was $60. I think so. That's what? 1.5 DSPs? The keywords for inducement in Greer's complaint are materially contributes, allows, and enabled. If Greer would have put the word inducement instead of allows, the meaning and the facts would have been the same. The lag of the word inducement shouldn't have disqualified the copyright claim. Law regarding advertising inducement. The court also misapplied the full application of Grokster by overlooking that the law would find that the facts, the frequently asked questions would indeed count as inducement. When Greer cited Grokster on pages 8 and 9 of Doc 26 and wrote, active steps taken to encourage direct infringement, such as advertising an infringing use or instructing how to engage in an infringing use, show an affirmative intent that the product be used to infringe and a showing that infringement was encouraged. But He doesn't advertise an infringing use or instruct how to engage in infringing use. He doesn't actually do that. You're wrong. Courts have held that frequently asked questions can be looked to establish website policies and give instructions to users, but he doesn't give them instructions on how to copyright infringe. The court overlooked that other cases within the 10th Circuit have cited frequently asked questions as counting as guidance in cases. Roe versus Albertsons. Writing Roe might also find helpful that frequently asked questions link on the website, which contain answers to frequently asked questions. Let's see. What do we got? These quotes are boring. Respectfully, the legal holding of advertisement inducement in Grokster and the 10th Circuit guidance of looking to frequently asked questions to establish guidance was overlooked and an error of law was made because it was never addressed in the court's judgment as to whether frequently asked questions counted as inducement. Plaintiff cited cases, particularly Grokster, indeed showed that facts would have qualified as inducement. Only if they induce, Russ. Having a frequently asked questions that talks about copyright is not inducement. Ugh. Law regarding looking to other jurisdictions for guidance. Court also made an error in not applying long-held law that courts are to look to other jurisdictions for guidance in handling cases have not been addressed in the 10th Circuit. That doesn't mean they have to follow them, Russ. That's how we get circuit splits. Plaintiff alluded to this in Doc 26, page 7, when plaintiff wrote, these cases should be followed because they are analogous to the instant action because they involve service providers, for which is what one of the defendants is. A case within the 10th Circuit that refused to follow the above cited precedent because the defendant was not a service provider. Here, the defendant is, and thus the case law should be followed. What circuit is Utah even in? Federal Circuit, Utah. Oh, it's in the 10th. So wait. But the case, I thought you said... This case was within the 10th Circuit. That's why I'm confused. He said he's talking about cases that aren't decided in the circuit, and then he cites a 10th Circuit case. Russ, this doesn't do what you think it does. Why are you like this? Even though the court rejected the argument that inducement was not needed on page 5 of the order in judgment because the 10th Circuit hasn't ruled on it, the court didn't apply Napster's holding for inducement and material contribution as cited in Doc 26, page 8 and paragraph 2, when plaintiff wrote, in applying district court precedent with Martin, defendant Moon and Kiwi Farms have created and furnished his website to allow copyright infringement. His site is a swap meet per Napster. No, it isn't. Napster doesn't allow commentary on the copyrighted work, Russ. But Kiwi Farms does. Significant amounts of commentary and criticism and critique. You should be familiar with them. Plaintiff cited the swap meet argument in Napster because it related to defendant's citation of Martin in their motion to dismiss, when the Martin court held that a contributory infringer is one who furnishes for intents of infringement. As stated in Doc 26, Napster held that one who supplies internet services for purposes of infringement could be held liable for materially contributing to infringements. That's all Napster did. It's basically the entire point of what Napster did. Napster was great, by the way, and the music industry made a big mistake in how they handled that, because they essentially could have just partnered and monetized, and they would do that a decade later after losing a whole bunch of money. But they could have done it then. They chose not to. But that being said, Napster's entire purpose was to distribute copyrighted music. That was the entire function of the web service. This was followed by Greer writing in Doc 26, without the service provider, the infringing users wouldn't be able to upload Greer's copyrighted materials and then allow for those materials to be downloaded. Yeah, that's not true at all. That's why Greer asked for Napster to be followed, because this case and Napster are analogous. Oh, yeah, they're exactly the same. There you go. Greer was asking for Napster to be applied in both of his legal theories presented in Doc 26 and arguments relating to inducement, no need for inducement. All of the laws and cases that defendants in this court relied on were not analogous to ISPs as defendants. Napster's not an ISP either. Napster has no functionality other than to upload some musical work to be downloaded by other users. That is the entire purpose of the service. There is nothing else happening at the time. At the time, I should say, there was nothing else going on Napster. That is entirely different. Kiwi Farms, there's no need to post. You could go to Kiwi Farms without ever posting a single photo, video, or anything else. There is another purpose. There is that's why Napster induced infringement, because it was the only thing that it did. It's not like it had alternative functions and people decided to infringe on it. That would be something like Facebook. And under this theory, all of these websites would be liable for copyright infringement. The court respectfully overlooked the cases within the 10th Circuit have cited Napster and followed it. Warner Records versus Charter Communications, where the availability of infringing material acts as a draw for customers. The biggest case boost to plaintiffs' claim that this court overlooked was found in the previously cited Warner Records case. Quote, the 10th Circuit has limited precedent on the issue of vicarious and contributory copyright liability. Judge Hegarty, therefore, appropriately relied on persuasive precedents from a variety of courts of appeal and other federal courts. He also correctly noted that the 10th Circuit cases that address similar issues cite particular 9th Circuit cases favorably. That doesn't mean that it's the same case, Russ. Based on that, there's no reason this court cannot look to other districts within the 10th Circuit and how they favorably cite 9th Circuit copyright cases, especially when the facts are very similar in Warner Records. In the court's order and judgment 9/21/21, the court actually does rely on and quote other 10th Circuit district court cases. Okay. They're not required to quote and cite a 9th Circuit case. Respectfully, the court made an error of law by not looking to other district courts within this circuit in how they cite 9th Circuit precedent based on the limited 10th Circuit precedent. If the law had been applied fully, the third prong of the copyright infringement claim would have been found in plaintiff's favor. Court made a manifest error of law by not allowing plaintiff to amend. Nope. Court said, you don't need to amend. All of this is stupid. The court is correct to note that Greer was not trying to supplement his complaint, but rather file a memorandum brief. However, he did not mean for that to waive any future chances to amend his complaint. The court has misunderstood Greer's position, which falls in a Rule 59e motion. Claims that the district court misunderstood a party's position should be raised by Rule 59e motion. Plaintiff would ask that the accompanying proposed motion for leave to file amended complaint be granted. His intent with filing the first and second supplemental briefs was to introduce new evidence, not to alter the complaint or waive any chance at amending, nor to cause bad faith. Russ, your pleadings do not require new evidence. Your factual pleadings do not require evidence. This isn't a slap case. Well-pleaded facts are all that's required. It's federal court. Well-pleaded facts are sufficient. They just have to be well-pleaded facts that support a prima facie inference that the defendant would be liable for every element of the crime, or not of the crime, but of the civil act. You don't need evidence. You need well-pleaded facts. You don't have them. As stated in part 1 of his motion, he believed he stated all three elements of contributory copyright infringement, so he never knew he would have to amend or alter his complaint to cure deficiencies. Russ, that means you are deficient. Like, I did it. I didn't know I would have to work more. You don't understand the claim. You never understood the claim. Okay. The accompanying proposed amended complaint should be granted because it's not being filed in bad faith. It is not futile, and there will be no undue delay. Plaintiff first wants to clarify that his past briefs and his proposed amendment are not in bad faith. Briefs not filed in bad faith. Plaintiff is sincerely sorry the court perceived his supplemental memorandum briefs to be that of bad faith. Plaintiff is only showing the court, as stated in the supplemental briefs, that people are suffering as a result of Kiwi Farms. That's irrelevant. It seems pretty relevant if people are literally killing themselves because of defendant's site for this court to know. Nope, that's not relevant, Russ. That's prejudicial. Hey, Attorney Tom, how would it go in court for you if you were filing a claim, say, against, I don't know, UPS, and you filed a supplemental brief to the court that says, over in Florida, a UPS truck ran over a dog and a child was crying. Actually, up in New York, a UPS truck ran over a cat and another child was crying. They're killing animals all over the country. All right. I mean, I guess. I don't know how that affects the instant case unless you can show. Tom says sanctions. Yeah. The only way that would work, by the way, is if you could show that UPS had a pattern, like an instruction to actually do these things. Like if you were showing it was company policy to run over animals or children, for example. Like, well, when you see a child running into the road from the right, make sure to swerve your truck to the right as hard as possible. If that was in the employee manual and you could substantiate it, then yeah, maybe that might work. But just citing a bunch of other incidents that happen, not great. Not great. It's not an alleged fact. It's been proven by news outlets and researchers. I wish I would have read that line first. News outlets wrote an article about it. Now it's true. That's why everybody kills themselves. Etika, Kiwi Farms. Seth Rich, Kiwi Farms. Jeffrey Epstein, Kiwi Farms. Ghislaine Maxwell, Kiwi Farms. The director of photography that Alec Baldwin just helped suicide, Kiwi Farms. As for bringing attention to the facts about defendant's attorney, it seems pretty relevant for this court to know that Mr. Skordas has taken on any case involving the plaintiff so that the court knows the deeper relationship going on behind the scenes. Nope. It's a private attorney. He can have a personal vendetta against you forever. This is a civil action. It might even be proper if Skordas were to pay Josh Moon for the privilege of ruining you in court. That might even be ethical. Ghislaine Maxwell was a joke. She's not dead yet. It's a joke. It's a joke. Oh, gosh. If anything, it shows that Joshua Moon closely follows Greer and isn't the unaware site owner he has been portrayed to be. When opposing counsel entered on behalf of defendants, plaintiff truthfully had a panic attack that affected his mental and physical health. Skordas. Could you imagine what that looked like? Oh, God. Russ just exploding. He truly wrestled for 6 months on whether he should inform the court of the past litigation history between Skordas and himself. In fact, the Federal Rules of Evidence Rule 401 allows the memorandum briefs put forth as it makes the fact more probable than it would be without the evidence. No, it doesn't. No, it doesn't, Russ. As for and even if it does, you're missing the other part of that. That's just probative value, but probative value has to be balanced with relevance and prejudice. I don't know where the lips are. I thought they were up here, but I can't find them. As for the news reports, they qualified as self-authenticating evidence per Federal Rules of Evidence 9026. They're not relevant. And even if they may be probative, they're prejudicial. And you're also not introducing evidence, Russ. You're just pleading facts. If it was not proper to file those briefs that provide new information, what would be the proper avenue? Oh, I don't know. Well-pleaded facts leading to your evidentiary hearings that would follow. You're not at an evidentiary hearing. Should the court not be aware of self-authenticating evidence that another person killed themselves because of kiwi farms? Especially since it was tied directly to kiwi farms and since the victim and his family even blamed kiwi farms. Well, I mean, you know what? That's true. If the victim and their family blame someone, it must have been their fault. And as a result of the suicide, the hosting server of Kiwi Farms, DreamHost, made Mr. Moon find a new domain because it didn't want to be associated to a site like that. Respectfully, how is that not relevant for this court to know that this website is not benefiting the public as defendants argued? The second brief was to show the continuing harassment stemming from Moon's site. That brief was relevant because it has been the same pattern of hate stemming from the users of that site, and to show the court the harassment is not stopping and probably will never stop. Now that the defendants are emboldened by a dismissal. That's your fault, Russ. Russ, you made Kiwi Farms worse. Defendants are emboldened by a dismissal knowing that they can't be stopped. Every person close to Greer knows how much Kiwi Farms has ruined his life, and he is respectfully confused why the court would see that in bad faith. He can apologize as if it was perceived to be in bad faith. With it shown that his briefs were not in bad faith, the proposed amended complaint would not be in bad faith because the proposed complaint would rectify the third prong of his copyright infringement claim. No futility. In terms of any proposed amended complaint being futile, courts have held that when the basis for denial is futility, we apply the legal sufficiency standard of Rule 12b-6 to determine whether the proposed amended complaint fails to state a claim. The accompanying proposed amended complaint cures the deficiency of the third prong that was allegedly missing in Greer's complaint or was too vague for the court to draw from. No undue delay. Defendants suffer no prejudice in allowing plaintiff to amend his complaint because no deadlines were ever given for plaintiff to amend his complaint. He also had no reason to believe he had to or should amend. As this motion argues, the court respectfully overlooked the facts showing plaintiff satisfies the third prong. No, they said that you couldn't cure it by amending the complaint. You've just failed. You got an F, Russ. It happens. The court admits plaintiff's life has to be made hard and difficult due to defendant's site's purpose of attracting the trolls. So it only makes sense for the court to allow Greer to amend his complaint to attempt to cure and clarify. No, it doesn't. The third prong that plaintiff strongly believes in is shown in his complaint if the court emphasizes with him. How does the court emphasize with you, Russ? What does that even mean? Wolvenar says, if you were the judge, how would you answer this? I'd just write lol, nah, lamau. And then sincerely, the Honorable Judge Rackets. He means empathizes, but the court's not allowed to empathize with you, Russell Greer, to make their decision. They can't go, well, we empathize with you, so therefore we'll let your defective filing through. The case implicates a matter of great public importance. A failure to reverse would result in manifest injustice. Nope. The public importance is that the public and plaintiff have suffered due to defendants. Normally protected by the Communications Decency Act, defendants open themselves up to liability by contributorily infringing on Greer's copyrights. This is very dangerous ground, by the way. Russell Greer seems to be arguing that he brought this claim of contributory copyright infringement for an improper purpose of making an end run around the Communications Decency Act. I would not be writing anything like this in a brief if it were me. If it were me, I would not admit that I'm actually mad about their protected activity, so therefore I'm bringing a bad lawsuit based on their purportedly unprotected activity. Just doesn't seem like a good idea. By not allowing Greer the chance to amend and cure the third prong by showing the inducement of his original complaint, defendants will continue to hound him. Oh, you think that it would have stopped otherwise? And infringe on his works for the rest of his life. Well, only till you end it all, right, Russ? Because that's what you said would happen. I don't want you to, Russ. Let me be very clear. I want Russell Greer to live a long, I can't say healthy, but a long, happy life where his giant lips are peeled back in a perpetual grin. I want him to live a long life. But he said it's just a matter of time for everyone on Kiwi Farms. But the defendants can't continue to hound you because the defendants have never hounded you. You couldn't get that there. At times, plaintiff feels he is stuck in a hole and that his life is ruined. Who did that? The dismissal of Greer's complaint took an emotional toll on Greer. Russell, you wrote in your book and everywhere that everyone discouraged you from suing Taylor Swift except your imaginary attorney friend. Everybody discouraged you from doing that. They said, don't do it. You were fired for doing it. Don't do this. Don't do this. According to you, you were fired for doing this. Don't sue Taylor Swift. Don't make a spectacle of yourself, son. We don't want to be attached to anything like that. No, I'm going to do it. She owes me that bitch. She owes me to give up that pussy. I want to eat that pussy. And she owes it to me because I wrote her a song. Like, don't, Russ. Don't do it. Oh, you did it. Well, you're fucking stupid. You said that everybody told you not to do it, but you did it anyway. No one ruined your life but you. No one ruined your life but you. The dismissal of Greer's complaint took an emotional toll on Greer, but he has gathered the strength to respectfully show the court that an error of law and fact was made in dismissing the complaint. Plaintiff kindly asked for this motion to be granted and for the case to be reopened for the proposed amended complaint to be granted. All right, how do we think this went? How did Russ do? Let's see. Before the court is Russell Greer's motion to alter and amend the order and judgment and to reopen the case. He cites Federal Rule of Civil Procedure 59E, which permits this sort of motion to be filed no later than 28 days. So it's because the court entered judgment on September 21st, his motion is timely. Essentially, Greer is asking the court to reconsider its order. A motion for reconsideration is appropriate where the court has misapprehended the facts, a party's position, or the controlling law. In his motion, Greer argues that the court overlooked the fact that plaintiff did indeed properly plead inducement. He then contends that the court misapplied the Supreme Court's holding on Metro Goldwyn Mayer Studios. Next, he chastises the court for not applying the Ninth Circuit's rule in A&M Records. Not the kind of language you want to see this early in a order. I would humbly suggest that that it doesn't say he I'm just not sure. Chastises is not a word I want to see when the judge is describing how I talked about their work. Finally, Mr. Greer states that the court misinterpreted his filings on 2 supplemental memorandum briefs as waiving any chance at amending his complaint. Instead, in his view, the court should have allowed him leave to amend. In his reply, Mr. Greer protests that the defendant's opposition memorandum was untimely filed, and as a result, it should be disregarded. The court will address each argument in turn. Defendant's memorandum. As an initial matter, Mr. Greer points out that the defendant's memorandum in opposition was not filed on time. Local rules state that responses to motion, other than those filed under Federal Rule of Civil Procedure 12B, 12C, or 56, must be filed within 14 days after service of the motion. Defendant's memorandum in opposition was 5 days late and contained no explanation for untimely filing. However, in the interest of resolving this motion in the litigation, the court exercises its discretion and will consider the defendant's response. In doing so, the court does not believe that it is exceeding the bounds of permissible choice in the circumstances. Okay, so what we didn't cover, there was a response to Russell Greer's motion, and then Russ filed a reply. I didn't cover those because I didn't want to read another 30 pages. The court says, he says that they're late and they didn't have an explanation. This court says, we're going to go ahead and accept it anyway. There you go. Not a good look, not a good start for Russ there either. Not good place to be. Again, this is early on in the motion, or in the ruling. It's only 5 pages. Inducement, Grokster, and Kiwi Farms frequently asked questions. Second, the court did not err in holding that Mr. Greer had not plausibly pleaded inducement in his contributory copyright infringement claim. Nowhere did the court say that Mr. Greer's failure to use the word induce or inducement was the reason his complaint was deficient. On the contrary, the court considered all the facts presented in Mr. Greer's complaint, construed them liberally, and read past any defects in Mr. Greer's use of legal terminology. The facts pleaded in Mr. Greer's complaint did not permit the court to infer more than a mere possibility of misconduct. Therefore, it was appropriate to dismiss his complaint. Oof. The court did not misapply the Supreme Court's holding in Grokster, nor did it fail to consider Mr. Greer's frequently asked questions argument. In Grokster, the Supreme Court wrote, oh no, the judge is citing the argument to Russell. Here, let me read it to you, buddy. Let me help you out. Evidence of active steps taken to encourage direct infringement, such as advertising an infringing use or instructing how to engage in an infringing use, show an affirmative intent that the product to be used to infringe, and showing that infringement was encouraged overcomes the law's reluctance to find liability when a defendant merely sells a commercial product suitable for some lawful use. But Mr. Greer's complaint did not demonstrate a plausible claim for relief for contributory infringement. Even under the theory that the defendant's frequently asked questions encourage direct infringement, Kiwi Farms' fact section allegedly says that the website, quote, does not host well-known copyrighted content. What copyrighted content Kiwi Farms does host is usually covered under fair use. These two sentences from the frequently asked questions do not advertise an infringing use, nor do they instruct how to engage in an infringing use. Fair use is not an infringing use. This is true even though the court did not need to reach the fair use issue in its ruling. That's what the footnote says. And Mr. Greer's assertion that the frequently asked questions encourage infringement on non-famous works is nothing more than speculation. This argument did not move Mr. Greer's claim from possible to plausible, and it was properly rejected. Moreover, the court was not required to give every possible reason to grant the motion to dismiss. The court did, however, give all of Mr. Greer's arguments full and fair consideration. To the extent that Mr. Greer seeks to revisit issues already addressed or advance arguments that could have been raised in a prior briefing, the court will not do so. Ouch. You had your shot, kid. You took it. You missed. You don't get another one. I'm Alec Baldwin. It's time now for a PSA on the proper use of firearms. Kids, you're going to hear a lot about firearms in the coming days, weeks, months, and even years of your life. In some cases, you'll have to maybe hold one, maybe use one. You never know what situations could arise. But let me tell you from experience, as an accomplished Hollywood actor with one human death under his paws, you'll always regret the shots that you don't take because you'll never get a chance again. So when you got it, take it. Thank you. This has been Alec Baldwin. The more you know. Okay, sorry about that. We just Just he fucking shot someone on set for no reason. No reason. Guys, there's so much coming out about this. It was a revolver. You would presume a single action revolver, which means not only does he have to pull the trigger, he has to cock the hammer before pulling the trigger. They weren't even shooting the scene, so the cameras weren't rolling. He wasn't even supposed to fire. His fingers shouldn't have even been on the trigger. Amazing. Amazing. All right, on to Napster. Third, it was not error for the court to decline to apply the out-of-circuit precedent in Napster. Oh, let's see what the footnote says. Although Mr. Greer cites Napster, the applicable Ninth Circuit rule also comes from Perfect 10 Inc. versus Amazon, which bases its holding on Napster. Simply put, Rule 59E motion can raise the court's misapplication of controlling law. But Napster, a Ninth Circuit case, is not controlling law in this district. A sister district court citation of Napster does not change this fact. Ouch. Leave to amend. Finally, it was not error to deny Mr. Greer permission to amend his complaint. As the 10th Court has emphatically held, once judgment is entered, the filing of an amended complaint is not permissible until judgment is set aside or vacated. Because there are no grounds to vacate the judgment, Mr. Greer cannot file an amended complaint at this late juncture. Of course, Mr. Greer's 2 proposed memorandum briefs did not waive his right to later amend the complaint, but he never asked the court for permission to amend his complaint, just for permission to, as he put it, introduce new evidence. Mr. Greer, quote, had an opportunity to seek the amendment before entry of judgment, but waited until after judgment before requesting leave. The court is under no obligation to give leave to amend when a plaintiff does not even request it. Damn. As an aside, Mr. Greer may well have had a plausible cause of action under the Digital Millennium Copyright Act, or even a claim for vicarious copyright infringement. See Grokster, defining various infringements as profiting from direct infringement while declining to exercise the right to stop or limit it. But it is improper for the court to assume the role of advocate for the pro se litigant. Mr. Greer failed to state a claim for contributory copyright infringement. While the court is disheartened to read that Mr. Greer feels that litigation process was unfair, he remains free to raise his concerns on appeal. As it stands, there was no clear error or manifest injustice in this case. Accordingly, because the court discerns no error in its ruling dismissing the complaint with prejudice, the court denies Mr. Greer's Rule 59E motion. So Russell Greer loses. As is proper, the world is correct and wonderful. But guess what, y'all? Russell Greer has already appealed. Just yesterday, Russell Greer, well, on the 26th, it's technically the 28th now, Russell Greer has appealed this case. And so it goes on. And so it goes on. To the Supreme Court. To the soft ass eyes moon, Alice. So there you go. That is the resolution of Russell Greer's district court case, finally resolved again against Joshua Moon and the Kiwi Farms. Now, interestingly, something weird has happened here. The judge says they might have had a claim for vicarious copyright infringement, might have had a DMCA claim. Well, if he didn't sue under the DMCA, which I don't think he did, he might possibly still have that claim. But vicarious copyright infringement, well, no, because he said contributory copyright infringement, right? Which is not vicarious copyright infringement. The question is he able to bring these in a separate lawsuit, or is he precluded under res judicata? I would argue that this would be precluded under res judicata. You have claim preclusion here. You have the same nexus of events. He tried to litigate them. He failed. If he tried to bring them back, it should not be revisited by the court. So I think the court is basically saying you could have done this, but you didn't. Sorry, too bad. Maybe you should have tried better. So it's seems to be over for Russ, aside from the appeal, which is going to take forever. That's going to take a long time. It's just going to sit there. As you guys know, with Vic's appeal, these things can just sit there and sit there and sit there. This federal court, it might even be worse. So there we go. Judge Tenna Campbell has ruled against Russell Greer on this day and on basically every day, and he has been denied. So that being said, let's get to this. Nope, we're not going to do it this way. Hold on. We have here Russell Greer's America's Got Talent audition. Thank you. Thank you to Kiwi Farms, Ken Jennings, for making this happen. Let me pull it up. I hope you guys are ready to be inspired, because that's what Russ Greer wants to do, is inspire all of us. Here, I got some space down here. Look at that. Ooh, that's a new StreamYard function, by the way, to put my face down in the corner. Let me make sure we've got the volume. All right, you guys ready? Are your bodies ready? It's 2.5 minutes of Russell Greer. Look at the sweat already on this man. Here we go. You think this is the right one? It better be, or I'm going to call you a piece of shit.
Hi, my name is Russell Greer. I am 24 years old, and I live in Salt Lake City, Utah. I am a variety act.
Yes.
And I am going to do a motivational speech.
It's America's Got Talent. You can do anything. You can choose anything you want to do on Earth. And you're Russell Greer. What is the one thing that you choose to do? A speech. Okay. All right. I'm going to try and not, once he gets going, I'm going to try and not pause it, but I just, that is premium.
While I play the piano and dance. For the longest time, I was upset because I had a disability. Now, I'm happy to tell you that I am the world's best ventriloquist. Today, I'm here to tell you that you too can overcome your disability in 3 easy ways.
3 easy ways.
Accept it. There's no point in being mad about things that can't change. And maybe I can't change this, but I can change other things about me. I can deal with it. Like using a slideshow so people know what the heck I'm saying. And number 3.
Yes.
Dance.
Yes. Yeah.
I'd like to invite you to come and dance with me.
Yes. Get it. Go, Russ. Yeah. Why didn't they pick him? This man is a genius.
I hope you enjoyed it, and I hope you felt inspired when we're dancing. I would really like to get on the show. As you can tell, I have an obvious disability, but I don't let it stop me. And I would like to get on the show and inspire people and show people not to hide, but to be happy with themselves and to love themselves.
Yes.
And to live their life. And my acts will be different every time. It won't be the same acts.
Won't be the same
I'm a
speech.
screenwriter. I do some stand-up comedy. I have a band play with me. I'm a variety act, so I can do anything. It would be awesome if you could please give me that chance to audition. Okay, I'll see you in LA.
Guys, he's a variety act. Every act's going to be different. He's a screenwriter. I can't think of a better act than watching someone screenwrite. He's something of a stand-up comedian, which is true. That's the best joke I've heard all day. Phenomenal. Every week it's going to be different. It's going to be great. Get him on the show. Gummy, he said he said he's the world's best ventriloquist. Why didn't he do a ventriloquist act? Like, that would have been genius. He could have done anything. He could have chosen anything, and he chose this. He's a screenwriter. He's a legal writer too. He's somewhat of a lawyer, actually. You've okay. So there you go. That I wanted to put that up because we're about to look at his lawsuit with I don't think we're going to get through all of this lawsuit. Oh, a lot of it is exhibits. Why? Why? Why is this picture in the lawsuit? Why did you put it in the lawsuit, Russell? I don't understand why you did it. It's Exhibit A. It's Exhibit A. He put it in here. Okay. So it is 35 pages. I don't know if we're going to go through it all. We're going to take a look and see what's in this complaint. So he has brought this against Fremantle Productions North America Incorporated. And then he says a corporation. So that's good because it was incorporated, but now you know that it's incorporated. Okay. Oh my gosh. One of the worst parts of COVID is I'm not physically capable of laughing without coughing. Plaintiff Russell Greer comes forward now with his complaint against defendant named above. Plaintiff brings this action seeking redress for suffering disability discrimination by Fremantle, an entertainment production company under the Americans with Disabilities Act, hereafter referred to as the ADA, in relation to plaintiff being discriminated and denied a chance to go on Fremantle's show, America's Got Talent. In addition to discrimination, defendant recklessly inflicted upon plaintiff emotional distress. So, it's his new Taylor Swift. This is his white whale. This is his Moby Dick, right? This idea that he is entitled to something of someone else's. With Fremantle, he's entitled to be on America's Got Talent. Hundreds of thousands of people try out for shows like this and are denied. But Russ is entitled and was only denied because they hate disabled people. Even though America's Got Talent, was it them or was it American Idol that had the blind piano player? I mean, they have disabled people doing amazing things on their shows all the time. All the time. It makes the acts insane. But no, Russ didn't make it. Not because his act was god awful. It's because he's discriminated against. He has a right to be on their show because God hates him. And so someone else doesn't have to. That's according to Russ, right? That's the only way. Taylor Swift, he was entitled to get in that ass because he made her a song. He made a song for Taylor Swift. Therefore, she must acknowledge him. She must show up. She must sweep him off of his crippled legs and give him blowies to oblivion because that's how it must work. That's how it must work. The world should be handed to Russell Greer. So jurisdiction, civil action. Where did he bring this? In Nevada. Okay. Seeking declaratory injunctive relief for disability discrimination and monetary damages for intentional infliction of emotional distress per Nevada case law. The court's subject matter jurisdiction over the action because it's a federal claim. And then they'll have supplemental jurisdiction over the case law. Court also has jurisdiction because there's complete diversity between both parties. The damage amount is above $75,000. Venue is proper in this district. Court has specific and general personal jurisdiction over defendant. Fremantle has made substantial contacts with the state. Either specific or general jurisdiction can be found on defendant. Specific jurisdiction can be found that Fremantle's show, America's Got Talent, offers the winner of the show a headliner show in Las Vegas. In addition to $1 million prize, has been a perk on the show since 2008. AGT is the same show Greer was trying to get on. Said show's perks was an advantage Greer was trying to obtain. This show's defendant has substantial contacts in Nevada that relates to the original cause of action, and Fremantle has purposely availed itself to Nevada. Probably. I mean, that's probably right. Additionally, Fremantle is partnered with the Luxor Hotel and Casino in Las Vegas to offer a live version of AGT. For the Luxor homepage, it reads America's Got Talent Vegas Live. The show will perform 2 times per night, 5 nights a week at Luxor Theater, etc., etc. The show has also been heavily marketed in Nevada. Yeah. Okay, we got it. Claim relate to the forum state because the prestige of having a Vegas show entice plaintiff. None of this is relevant. They do a show in Vegas. They have one in Vegas. Why do you need to keep doing this? Applying Ninth Circuit's test, but for test for specific. He's overwriting this. I'm not going to keep reading that shit. Oh, and now he's got a general jurisdiction claim. Are they organized? Wait. Just to double check. Fremantle. We got to check where their headquarters is. Does he say? Oh, he's got the party section. Okay, never mind. We'll see what he says there. Fremantle is essentially at home by maintaining an active business and registered agent in Carson City, Nevada. Fremantle has an active business license in Nevada. Blah, 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 blah. Heavily investing in Las Vegas. Yeah, okay. Substantial contacts, parties. Russell Greer resides. Okay. Hold on. Let's see. Just a second. Fremantle Productions North America is I got to figure out, rebranded as Fremantle. What's the actual? Based in Burbank, California. Let's see. Where's its principal place of business? Where's it incorporated? Let's see if it says it on the website. About. Oh my God, I hate their website. Fremantle is a UK company. Okay, here's the problem. Sorry, this breaks me. I was under the impression Russell Greer lived in Utah. I was under the impression that Russ lived in Utah, but I forgot he lives in Vegas. If Fremantle has their principal place of business in Vegas, then that would put them both in Nevada. So they're incorporated in Burbank, California, produces many different reality TV shows. But where's their principal place of business? Maybe it's not. I don't know. If they're incorporated in Burbank, where their principal place of business is really, really matters. It also matters if the subsidiary company if there's a subsidiary for AGT is based in Vegas, because they may not have diversity jurisdiction. But they have federal question jurisdiction. God damn it, Russ. If it's a federal question, then you don't need the diversity jurisdiction anyway. All right, sorry, I'm going off on a tangent. Plaintiff Russell Greer resides in the state of Nevada. Greer also has a facial disability termed Mobius syndrome. This essentially means that Greer's 7th cranial facial nerves are paralyzed, and so he cannot close his lips, and the daily life functions of communicating are difficult. For instance, though he has a paralegal degree, his disability has made it hard to find work in law firms or in a high-paying position because communication is essential in those roles. Okay, Russ, first of all, you have a paralegal degree. That's what makes it hard to find job in a high-paying position. That's the high-paying position problem, is that you have a paralegal degree. Second, it's not your disability that's the problem. Law firms around this country are notoriously woke and happy to hire people with all sorts of infirmities or disabilities because they just do. They do all the time. They hire mute lawyers to make oral arguments. And no, I'm not joking. Not only is speaking difficult, he is also often shunned for his deformity, thus limiting his social opportunities. Why'd you try to be a paralegal? Why? But paralegals don't actually need. Never mind. Defendant Fremantle is incorporated in Burbank, California, produces many different reality TV shows. Now, notice Russ says he resides in the state of Nevada, not that he's domiciled in the state of Nevada or that he is a citizen of Nevada, which was a problem in the Gavin McInnes lawsuit, right? The judge, after 18 months, finally said, oh, yeah, you can't just say resides. So, but I don't know if it's a federal question under the Americans with Disabilities Act, it doesn't matter. He doesn't need diversity jurisdiction in that case. But anyway, they produce many different reality TV shows, namely show America's Got Talent, hereinafter referred to AGT, which is a show Greer auditioned for and knows he was discriminated by the producers from appearing on the show. The court has jurisdiction over defendant. All right. Background of plaintiff. Fuck me. Let's see how much of his background he put in there. Greer has had a long-held dream of getting into the entertainment industry as a songwriter and an entertainer, but with a facial paralysis. His dreams have been stifled and hindered because of his disability, because communication is essential as an entertainer. Greer's disability is such a speech hindrance that he even has trouble pronouncing his own last name. When he says G, some think he's saying P. He can't use his lips to form clear words. Greer. Wait. G's don't require your lips. Greer. Russell Greer. Greer. The G sound comes from. He has had to do years of speech therapy to get where he's at in his communication level. So it should be no surprise to this court that his disability puts him at a disadvantage as an aspiring entertainer. Okay. You've just gone ahead to show one reason why America's Got Talent may not actually have wanted you. That's not based on your disability, but in high school in 2009, Greer was in the drama club, and the club went to different schools to perform skits. And Greer can remember being laughed at by audience members because of his disability. Can you imagine being in high school and someone shows up from another high school drama club to do skits for you, and it's Russell Greer? Like, oh my God, can you imagine? Why would you do that? Shortly afterwards, his teacher urged him that if he pursued his entertainment career, he should stay behind the camera. you have a face for radio and a voice for space. Greer has seen opportunities taken from him because of his disability throughout his life. Greer's entire life has been filled with the search for purpose and belonging. Growing up in Utah, Greer didn't really have any serious entertainment options to pursue. His family flirted with the idea of him being an extra background actor in LDS professionally produced movies, but they weren't sure how casting directors would react with a disability on camera. Those Mormons, those bastard Mormons, don't want the disabled running around shitting up their expertly produced movies as extras in the background going. In 2015 to 2016, when Greer was beginning to get serious about his musical pursuits, he had many heartbreaking experiences of trying to work remotely with out-of-state music producers, but because of his disability, they couldn't understand him. This isn't a problem a non-disabled musician faces. It was his Taylor Swift song. It was his Taylor Swift song that he's talking about. When Greer has posted videos online of himself playing music, he has been mercilessly harassed by trolls who have attacked him for his deformity, which is another struggle non-disabled musicians don't face. Yes, they do, Russ. Have you seen like how Adele is treated? Adele was fat shamed for being fat, and then Adele was skinny shamed for not being fat. People go through all sorts of criticism as non-disabled musicians. What are you talking about? When Greer has posted videos online of himself playing music, oh yeah, which is it is interesting how in a world that champions underdogs, strangers can be so cruel to those they do not know. What world champions underdogs? Yeah. Go get him, Jeff Bezos, you underdog. Go get him, Elon Musk, you poor little rapscallion, just fighting against the odds over here. What is he talking about? Our world so heavily favors the overdog in literally every society that it's embarrassing. When we are rooting for the underdog, we're hoping little Timmy with no legs can get a job at McDonald's. We're like, oh, finally, he did it. Like that's us rooting for the underdog. We're not saying that they're going to be CEO of Amazon or that they're going to be a Grammy Award-winning musician. Like, oh, come on. Greer's disability has caused him to doubt his own talent at times. It's not your disability, Russ. It's your talent. As he is a talented entertainer stuck in a body where he can't clearly express himself, or where others have doubted his talents because of how he looks. For years, instead of chasing his dreams, he was discouraged and working as a janitor. And one fine day, while working as a janitor, he would wear a tuxedo, get on a bus from Salt Lake City all the way down to the Bunny Ranch, go and hire a prostitute for 4 wonderful hours for several $1,000s. He would not have sex with the prostitute, however, at the Bunny Ranch. He would instead hire a limousine and take her to the most fancy restaurant in the in the Nevada area, the Olive Garden, where they would spend time eating and conversing, while he would mostly slurp minestrone through a straw and then drool out remnants of it on the table. By the time they got back to the Bunny Ranch, Russell Greer's 4 hours would have elapsed and no coitus would take place, because even though the Olive Garden was not opened when he started his 4 hours, he insisted on talking to the prostitute rather than having pre-Olive Garden sex with her. Which, if I'm giving you life advice tips, by the way, and you're going to hire a prostitute and you want to take her to lunch because you don't understand how prostitution works, but just in case you do want to do this, if you're going to take a chick to a place that serves primarily carbs and cheese, have sex with her, and garlic and onion, have sex with her before you go eat. This is a pro tip. This is a pro tip. I am giving you, this is words from the master. If you're going to pay for a prostitute's lunch, you just paid for like her month. If you're going to pay for a prostitute's lunch, have sex with her before the carbs, the cheese, the garlic, the onions, and possibly broccoli. Don't do it. Just have sex first. Okay. But yes, that's a true story. Russell Greer did an entire shift in his tuxedo. That's the other thing. If you're going to visit a prostitute and you have to take a bus from Salt Lake City, Utah to the Bunny Ranch, which is, I think, a 6 to 8 hour bus ride, and you have to do this overnight, and you've got your janitor shift at Walmart first, don't wear your tux for an 8-hour janitor shift at Walmart, then wear your tux for a 6 to 8 hour bus ride to go visit a prostitute. This man was in a tuxedo doing janitorial work and then on a public bus for 16 hours in this tuxedo. And then he shows up. The smell alone. And my final pro tip, if you're going to go to the Bunny Ranch to hire a prostitute, don't wear a tux. At best, wear a polo. What are you doing? Why would you show up? Why would you put in all this work? You're paying for it. You don't have to earn anything. You don't have to fool her. You don't have to like woo her. Here's $4,000. That's it. You did it. Hooray. You swept her off her feet, right onto bed, right out of her clothes like Bruce Almighty. Just because you go, here's $4,000. Done. That's all you had to do. You drool all over her for the rest of the day. Guys, don't wear a tux. Don't wear a tux. Okay, sorry. As shown, not only does Greer face the struggle of communication, he also faces the struggle of being accepted by society and trying to be seen as more than a deformity. Fighting to be given chances in not just the entertainment industry, but also in his college degree field of law as a legal assistant. No, as a paralegal. Your degree is paralegal, not legal assistant. Besides his disability struggles, Greer has faced the struggles of the Hollywood system that is grounded centrally on networking and nepotism. because because of it's again, it's not that millions of people want to get into Hollywood. He can't network because he's drooling all over the place because of unsolicited policies and not knowing anybody within the industry. Greer has essentially spun his wheels in regards to his efforts. Says every barista in LA, by the way. At times he feels like a failure. Well, Greer has written and produced many songs, which are on streaming platforms like Spotify. The effort it takes for him to produce these are tremendous. He works with a professional producer who helps Greer tie up the loose ends of his music. Greer writes all of his own music. The effort costs him a lot of money for the production costs, hiring vocalists and for the mixing and mastering. Despite working with producers and being talented, he again is stuck in the rut of not having the right connections. Greer figured a reality show like AGT would give him much needed publicity to jumpstart his entertainment career. Many musicians have started their careers this way. Now, America's Got Talent. Now that we've gotten Russ out of the way. Your mental illness. I think somebody did dox Russ's prostitute. She's referred to as Kira, I think, in the story about it. But I think someone did find her real name or it's come out somewhere, but I don't think she's available for interviews. Maybe if I had crack. Okay, here we go. AGT. I think I'm going to probably stop the Russell Greer lawsuit in a little bit and go over to Marshall and Melinda because this will take a while. This is 35 pages, so we're 1/5 of the way through, and there's a lot more to go. So I don't want to spend all night on Russ. America's Got Talent, AGT, is a reality television show that launched in 2006. The premise is to find unknown talent, although many acts have had varying degrees of success before even going on the show. Yeah, it's almost like if you're successful elsewhere, you might be successful on America's Got Talent. You just are being exposed to a bigger platform. And have those acts compete through different rounds in front of celebrity judges for $1 million prize. The judges buzz off acts they don't like and have the acts they do like proceed forward in the competition. The acts get narrowed down to a top 30 group where a live audience and viewers can vote who moves forward. AGT was the perfect reality show to give Greer a boost to his entertainment career because the show has a variety of acts that go on, whereas other shows are strictly limited to one category like singing or cooking, etc., and the contestant is limited to one person, whereas groups can go on to AGT and act as a single contestant. AGT is a type of format where Greer could have an accommodation, other entertainers help him with his act, as doing a solo act wouldn't be feasible. Wait, are you? There's a reason that he said that. Whoops. Here we go. God. Get on here. This is what gave me pause. Russell is bringing this case under the Americans with Disability Act. Okay? There's a reason he said accommodation. Because accommodation is a legal term of art under the Americans with Disability Act. Is Russell Greer going to suggest that they would owe him other entertainers for the opportunity? Like America's Got Talent would have to provide entertainers to Russell Greer for him to use in disposal with his act? Is that what's going on? He, in his audition tape, he calls himself a solo act. The important thing about AGT is that it's not a cutthroat competition show to get on. Say like American Ninja Warrior, where world-class athletes compete for a prize. No, with AGT, the producers look for unique acts with inspiring life stories. Sometimes the show will have on very silly acts like a guy singing Tequila Song with karaoke. Did he win, though? Per the official audition site for the show, America's Got Talent Auditions.com, the show's producers offer the following advice for auditions. Be original, stand out from the crowd, be fearless. Audition tips and advice. The show regularly features sob stories of people talking about different adversities in their lives, such as a blind contestant with autism. I know I like Thomas the Train, even though I've never seen him. Or a man wrongly incarcerated in prison for 23 years. This all led Greer to believe that if he tried his best, he could honestly make it on the show, as he could inspire others with his story and his talent. Okay, reasonable modification. Here it comes. Here it comes. Several competitions and tournaments have allowed disabled contestants to have reasonable accommodations. The most notable example is the Supreme Court case of PGA Tour versus Martin, where the court allowed a disabled golfer to use a golf cart. The decision came down to deciding that such an accommodation didn't alter the nature of the tournament, where contestants usually just walked. They don't usually just walk. It's a rule that contestants walk the course and not use a golf cart. Like, that's a rule of the PGA. For whatever reason, they like that rule. So it's not just they usually walk. And that's why the guy was given an accommodation to do a golf cart with whatever disability he had. The accommodation was also found to be necessary for Martin to compete in the competition. Likewise, Greer needed an accommodation that made it necessary for him to compete on America's Got Talent. Greer wanted to perform an original pop song he wrote about show judge Heidi Klum. And since the song, it's always an original pop song about some, at least formerly hot chick. It's always a song about a celebrity chick every fucking time. And since the song involved singing, Greer needed to invest in an accommodation, a vocalist to be his song's vocals. As Greer himself cannot clearly or coherently sing because of his disability, the accommodation fit within his talent, as he is a songwriter and he writes songs and his songs involve lyrics. Hiring an accommodation, Greer didn't just wake up one morning and decide to audition for AGT. Rather, his audition was planned out a year in advance in February of 2020. He was going to audition for the 2021 season of AGT. The audition would be a cattle call, open preliminary audition in front of producers who then would select contestants to audition on the show in front of the judges. With his producer, they produced the audition song, which was an original song about AGT celebrity show judge Heidi Klum. They studied successful acts from different musical shows and created the style of the song based on what had been successful while showing originality. To be extra original, we looked at a bunch of other songs and mirrored that. Okay. The song would then act as a reference song for a live band to follow. Greer then spent the next several months saving up money to find professional bandmates to help him perform the song, as due to his disability, he is unable to audition by himself a pop song, e.g., he can't sing the lyrics clearly. He should have tried. It would have been a better act. How are you a unique act? How are you unique and original if you just hire some generic musicians to perform music? There are generic musicians performing music in every bar in America. Greer was unable to find talent in Utah, so Greer made the move to Las Vegas, Nevada to find talent to help him in December of 2020. Greer currently lives in Vegas. So he moved to Vegas for America's Got Talent just for this. Once he was located in Vegas, Greer reached out to different musicians for connections. He eventually found a drummer, a singer, and a backup dancer. Greer was on the keyboards and a guitar he specifically bought for the audition. His accommodations are professional musicians who have done jobs on the Vegas Strip. Greer then used his money to rent rehearsal space in a rehearsal studio in Las Vegas. In total, Greer spent roughly $3,000 for the audition. As explains, the costs were an accommodation to his disability because Greer is already a disadvantage with auditioning. America's Got Talent has to pay for me to hire people. What? Michael Palmer. Hey, what's up, man? He says, "Hi Nick, I was wondering what would be the best way to put you in touch with Danny Trejo if you still wanted him as a guest on your show." I email. What does he do? Does he text? Machete don't text, but does Danny Trejo text? I have no idea, man. Email me or message me somewhere and we can talk about it. And figure that out. I don't know. I don't know how he communicates. The day of the cattle call audition. The day of the cattle call audition was February 8th, 2021 over Zoom. All auditions would be done virtually because of COVID. Greer and his band set up a Zoom call to have a video call with a Fremantle producer to perform the audition. Imagine, that would suck. That would suck so much. Like, this isn't a Greer thing. This is an everybody thing. You're a musical act or whatever, and you're going to audition via Zoom with this shit audio and connection that Zoom has. That would be terrible. My kids sometimes have to do their piano and violin lessons via Zoom, and it sounds bad. All right. Greer also had to fill out an information form, and in that form, he explained he had a disability and that his efforts were being done as an accommodation to aid said disability. The audition went smoothly. By the end of the act, the producer was clapping and told Greer he enjoyed the act. The producer asked Greer to submit the video on the online portal as well and then told him good job. Oh, no. Per the contest rules, all acts would be notified by spring of 2021 as to whether they made it on the show to audition in front of the celebrity judges. After the audition, Greer's bandmates were jumping up and down and hugging Greer, ecstatic. They all assumed, based on the producer's reaction, that they had made it onto the show to audition in front of the celebrity judges. Oh, no. Oh, no. Russ. Why? Months passed by with Greer so optimistic to receive an email from the producers. But an email never came. Greer also noticed that the YouTube video he submitted at the producer's request also was not viewed. Greer began to grow worried. The YouTube video was important because it contained a better quality audition than the Zoom audition. April 2021 approached, and although he never received an email from the producers, one of the celebrity judges posted on Instagram that filming had started. Greer was shocked. He began to have a panic attack and he vomited. He was in disbelief because the producer's reaction did not match the end result. Surely something happened during the period of months. It must have been something. In a haze, Greer reached out to a producer on 3/26/21 on the AGT helpline email and was told again to try again next year by a person running the email. Email gave no specifics on Greer's audition, just to try again. After spending $3,000 on this audition, Greer couldn't believe the response. Greer figured he could try reaching out to a producer for reconsideration, so he sent Fremantle a letter and sent it to the Burbank location in April of 2021. Greer waited 2 weeks and received no response. Greer then hired a lawyer under contract to write a reconsideration letter on his behalf. Citing the facts and claiming Greer was a victim of discrimination, asking for reconsideration. The letter read, "To whom it may concern, our office has been retained by Russell Greer in connection with..." Oh, God. Imagine having to write this letter. Oh. Whose office? Oh, God. He included the whole letter. All right. Our office has been retained by Russell Greer in connection with America's Got Talent's denial of Mr. Greer a chance to perform on the show. Please accept this correspondence as a formal request for reconsideration as to Mr. Greer and his band to be given an opportunity to perform on AGT. Hawley keep paying the band. It is our understanding that Mr. Greer auditioned for AGT this past February. Mr. Greer has a facial disability termed Mobius syndrome, which has made all aspects of his life difficult, especially with communicating. In essence, Mr. Greer's 7th cranial facial nerves are paralyzed and he cannot close his lips. Mr. Greer worked really hard on his audition and spent $2,000 to hire a band to help him. When Mr. Greer auditioned at the virtual audition, the producer really liked Mr. Greer's work and requested that he submit videos through an online process. Everybody had to submit videos. That's how they did it. Mr. Greer and his band, I'm guessing, Mr. Greer and his band were very excited as they thought that the encouragement from the producer indicated they had made it on the America's Got Talent. However, Mr. Greer never heard back from the producer or AGT and learned that filming had already started, reflecting that Mr. Greer and his band had not made AGT. Thereafter, Mr. Greer learned that the videos he had submitted at the request of the producer were never viewed. Mr. Greer wrote a letter to the producers of AGT, asking them to reconsider their decision. No one has replied to Mr. Greer's correspondence. Mr. Greer feels he was discriminated against by AGT and its producers. Why do you have an apostrophe there? That's not even where you would accidentally put an apostrophe on its. Like if you use the wrong form of its, the apostrophe would be between the T and the S. So not only did you get it wrong, you got the wrong one wrong. Through his work in music, Mr. Greer attempted to convey his story of overcoming adversity, demonstrating how he did not let his challenges stop him from accomplishing his dreams. Is that why he wrote a song about Heidi Klum? Mr. Greer contends that he has the talent and skill to be granted a spot on AGT, and he has demonstrated his talent in the video he submitted at the request of the producer. Mr. Greer believes he was indirectly discriminated against in light of AGT's denying him a spot. Mr. Greer's face is paralyzed and he has trouble communicating, and thus he was at a disadvantage when auditioning. That is the reason for him paying $2,000 to two professional band members to perform a song. Pursuant to the Equal Employment Opportunities Commission, indirect discrimination occurs when there is a particular policy that affects persons with disabilities unequally. Here, AGT rejected Mr. Greer's position on the show, and that rejection was based on discrimination. Because AGT failed to take into consideration that Mr. Greer had to put together a production to demonstrate his talent because of his disability, Mr. Greer is unable to go out on stage and perform a song by himself. Yeah, I mean, it makes sense. How, you know, if you're too disabled to present your talent and you're forced to hire someone else to be talented for you, I mean, this all makes sense. Vientigas, it was $2,000 for the band and presumably $1,000 more for the rental space. Therefore, based on the above, Mr. Greer hereby makes a formal request to sign a contract with AGT to perform on the show in 2022. He has already auditioned. He was applauded and praised by the producer, and he produced further videos of his songs at the request of AGT's producers. Mr. Greer has demonstrated his skill and talent, which is the basis for having him perform on the show. We have consulted with our client regarding his available options and avenues of redress, and we have been authorized to engage in confidential settlement negotiations. If you have any interest in resolving this matter in such a manner, please contact the Greer. You know who's got talent? The lawyer that wrote this letter. More appropriately, the lawyer who took your money to put this garbage out. What a trash letter. Like this. Okay. All right. I want you guys to get in a helicopter, fly it out over the ocean with a harpoon gun, and shoot it down into the water. That's what this lawyer just did. And hopefully they're going to tow back a whale into shore that they can sell, right? Like that's the idea. It's a complete waste. This letter is an absolute it's a nothing. We've consulted their available options and avenues of redress. We're authorized to engage in confidential settlement negotiations. So if you'll settle with us, that's literally it. There's no threat. There's no citation to an ADA claim that has any plausibility. There's nothing. It's literally just, look, we got this stuff and we've been authorized to settle with you. And notice he's going at this pro se. If you have any interest in resolving this matter in such a manner, please contact the undersigned via email, and we will have an assistant or paralegal contact you to schedule a call. Please ensure you reference Russell Greer in the subject line of your email. Our client wishes to resolve this matter amicably. We look forward to hearing from you or your representative to discuss the matter more meaningfully. Said firm was solely retained for writing the letter and representing plaintiff in modification terms. They are not involved with the current case because they don't work on a contingent basis. Oh, shocker. You couldn't find a firm to take up your case against America's Got Talent under the Americans with Disabilities Act. You couldn't find a firm to do that under fucking under a contingent arrangement. Why not? Why not? If they could if you could find one, they would do the letter as part of the contingent representation. But just shocked that you couldn't find a firm to do this. All right, at the next section, we'll switch over to Marshall. The letter was delivered to Fremantle. Soon afterwards, Greer's YouTube video suddenly had views. The video was set on unlisted, so only those with the link could view the video. So this confirmed the Fremantle producers received Greer's request. I mean, not necessarily, actually. YouTube sometimes will review things. I will get views on unlisted videos prior to anyone else seeing it, prior to me distributing the link, because YouTube reviews videos. Their algorithm does. It counts as a view. It's weird. I don't know why. It just does. Greer waited many months for a reply and never received any reply. Greer made contact with Fremantle VP of Legal Affairs, Kovan Sati, in September of 2021 and still received no reply. In fact, it wasn't just one message Greer sent. Greer made 4 messages to Kovan Sati between September and October of 2021. He also reached out to Diane, Kovan's assistant, and 2 different listed ADA emails. He also left a voice message on Kovan's phone. This poor sap is just having so much Russell in his life. So much. He doesn't even know what to do with it. Oh. John Russell, yeah, it's probably a human reviewer. I'm just saying, sometimes I get them before anything, but that doesn't mean what I'm saying. I don't know if a human reviewer would be reviewing Russell's material here. Probably not, but it's possible that something happened. But anyway, thus, it wasn't just one message that probably got lost or buried. It was 8 messages in a span of 6 months from Greer and the attorney under contract who were trying to make an ADA allowed modification request. 8 polite and professional messages. To ignore the request without any explanation or response is discrimination per the statute language of U.S. Code 42-121-822A2. I can almost guarantee you that this is legally incorrect. Fred blogs. Yes, I've seen the Ruby Rose stuff, and I'll potentially be covering it very soon. This is a 1,000 likes drink. Thank you guys for hitting that. 1,000 likes. I think I'm going to leave it here on page 14 with Russ. Because I kind of want to do the Marshall videos, whatever they are. Where are we? All right. So we're going to switch over to that. Martial Law versus Ricada Law 2. God, oh boy. Not part 2. That was before. This is number 2. So this is actually a new video. I've not watched this yet. What I need to do is get this video to an appropriate size here. Come on now. Let's see if we can do this. Share screen. Here we go. Can I shrink this even more? Oh, that's what we want to do. I guess. Weird. Okay, here. Oh, wait, we got to get there. There we are. Okay. I got to get my headphones. Let me do, I got to make sure I've got the audio on this because I did it a little bit different. Okay, so share tab audio is on. Okay. So this should work. If it doesn't work, I know you're lying, chat. Mandy Carvicus says, I've begun work on drawing a few MS Paint caricature sketches for your upcoming Color of Law coloring book, Nick. I'll have to run them by the mods for approval once finished. But do you have any requests before I continue? No, I am not representing to anybody that I am going to make and accept submissions for this coloring book at this time. If you want to make something and send it to me, I will certainly look at it, but I'm not making any promises to anybody or anything like that. I don't know what to do just yet with it. And I don't want people thinking that if they send me something, it's going in the book because, Russell Greer does that and we're not doing that. Okay. So here we go.
This is martial law versus Raketa law round 2. Anyways, I saw your video.
This motherfucker put Terminator music. He put Terminator music in this. So I'm going to pause it and comment a little bit. We'll see what happens.
And I decided to respond to it again. Anyways, I agree.
Okay, fuck him. I get it. I get what's going on. Let me see if he changes at any point. Give me a minute. Yeah. The entire thing is just it's just copyrighted music. So too bad. Too bad. Oh man, let me check the other one. What a pussy, right? He's a little afraid of criticism. That's the other one that he did too. That's the other one is it's just copyrighted music and a picture of my face. So, completely pointless. Well, that was lame. That was lame. Nix Hex, it's, isn't it fair use? No, well, his use of the music is not, but see, what'll happen is YouTube will just take the monetization from the video. Is what he wants to do. So I'll review the videos. I'm pretty sure, I don't even know if he makes any arguments at all, but so I'm not going to do, I'm not going to sit here and just do it. The second one has no audio or has no commentary. It's literally just my face and some music in the background. So Nix Hex, no, you can't necessarily appeal the monetization. Not that simply. No. So I got to check it out. I'll check it out. The problem is you can't hear him talk. The music is really loud. So it's, he's defeated his own ability to do this. Like I'll skip to a random spot in it just to show you. All right. Like here. The DMCA bot, the copyright bot is different than the monetization. Yes, it checks past 2 hours. 100%. I know this one very well. But here, listen, like when you go here.
Also, he commanded his disciples to go out and buy swords. And you have a movement going on in here. It's been going on for...
Notice he's not actually saying anything about me.
You know,
it's entirely generated to cause the copyright claim. So unfortunately, no attention will be given to that because there's nothing to actually talk about. Very, very weak. Very weak. Remember, Marshall's kind of a badass in the streets, which is why he would just load his video with copyrighted music. Because see, his channel isn't monetized. He only has 112 subscribers, doesn't have enough views. So it doesn't matter if there's a copyright claim made on his that prevents monetization. So anyway, too bad. Too bad. Big tough Marshall can't actually make an argument. It's weird. I thought he was a rough and tumble throwdown kind of guy, but apparently not. All right, let's see this. Let's see. Let's do this one. All right. We'll go to a different meme LoLcow, and that is Merrick Garland. So let's check this out. We've got here we go. All right, so this is Ted Cruz talking to Merrick Garland. Merrick Garland is in front of the Senate over this school board memo that he wrote about investigating parents as domestic terrorists, right? Because if you are a parent and you go to a school board meeting and you disagree with the school board, you must have lots of white rage and be a violent domestic terroristic monster. Here we go.
Thank you, Mr. Chairman. For 8 years under Barack Obama, the Department of Justice was politicized and weaponized. When you came before this committee in your confirmation hearing, you promised things would be different. I asked you specifically, quote, will you commit to this committee that under your leadership, the Department of Justice will not target the political opponents of this administration? Here was your answer, quote, absolutely. It's totally inappropriate for the department to target any individual because of their politics or their position in a campaign.
Whoops.
That was your promise just a few months ago. I'm sorry to say you have broken that promise. There is a difference between law and politics. And General Garland, you know the difference between law and politics. Law is based on facts. It is impartial. It is not used as a tool of political retribution. This memo was not law. This memo was politics. On Wednesday, September 29th, the National School Board Association wrote a letter to the president asking the president to use the Department of Justice to target parents that were upset at critical race theory, that were upset at mask mandates in schools.
Call out the rape.
Target them as domestic terrorists.
Call out the rape. Call out the rape. Rape. A boy in a skirt. Don't know if he was transgender in Loudoun County, Virginia. Loudoun, whatever it's called. Raped now 2 girls. raped, has been swept under the rug by the Loudoun County superintendent who knew about the incident, has been swept under the rug by the school board. The dad is being called the poster child of domestic terrorists. His daughter was raped in a bathroom in school in Virginia, who adopted a transgender bathroom policy. Rape, 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 rape. Lots of rape. The Department of Justice is going after the dad, is going after the people like the dad. The dad was arrested at that school board meeting when they denied the rape, even though Boy in Skirt is apparently federally indicted on this issue. Biden's administration, in pursuing their school board critical race theory bullshit, is supporting literal rape and covering it up.
On the face of the letter was in repeated consultation with the White House, an explicit political consultation with the White House. That was on Wednesday, September 29th. 5 days later, on Monday, so right after the weekend, boom, you pop out a memo giving them exactly what they want.
Should have said you shit out a memo.
Now, by the way, I understand that. In politics, that happens all the time. An important special interest wants something. Sir, yes, sir. We're going to listen to them. Let me ask you something, General Garland. In the letter, which you told the House of Representatives was the basis for this abusive memo targeting parents, how many incidents are cited in that memo?
I have to look back through the memo. I
Okay,
can't count it.
you don't know. How many of them were violent?
Again,
I don't know.
The general report.
How many of them were violent? Do you know?
I don't know.
You don't know. There's a reason you don't know. Because you didn't care, and nobody in your office cared to find out. I did a quick count just sitting here. During this hearing, I counted 20 incidents cited. Of the 20, 15 on their face are nonviolent. They involve things like insults. They involve a Nazi salute. One of the examples. My God, a parent did a Nazi salute at a school board because he thought the policies were oppressive.
By the way, you 100% have a right to Nazi salute at a school board meeting. Without question, protected political speech. Without question. And the notion that you can't do so is a facial affront to the First Amendment. This is the most political, like it is quintessential political speech at a state function. Of course you can Nazi salute. They're calling the teachers Nazis, right? He's not like right stuff, like that's not him doing it, right? He's telling the school board what has happened.
General Garland is doing a Nazi salute at an elected official. Is that protected by the First Amendment?
Yes, it is.
Okay.
Of course it is.
15 of the 20 on the face of it are not violent. They're not threats of violence. They're parents who are unhappy. Yet, miraculously, when you write a memo, the opening line of your memo, in recent months, there has been a disturbing spike in harassment, intimidation, and threats of violence. You know what? You didn't look, and nobody on your staff looked. Did you even look up the 20 instances?
As I testified, the decision to make send the memo is for an assessment.
Did you look up the 20 instances?
I did not read.
Did anyone on your staff look them up?
I don't know the answer, but it's not
But
only
of
the
course
memo.
you don't. In general,
Did you even look? I did not. Did anybody look? I don't know. Oh my God.
there's a reason. Look, you started your career as a law clerk to Justice Brennan. You've had many law clerks during the year, during your time as a judge. I was a clerk to Chief Justice Rehnquist. I'll tell you what, if I drafted an opinion for the Chief Justice and walked in and it said, there's a disturbing pattern of violence. Well, Ted, how do you know that? Well, I got an amicus brief here who claims it. You would fire a law clerk who did that. You're the Attorney General of the United States. This was not a tweet you sent. This is a memo to the Federal Bureau of Investigations saying, go investigate parents as domestic terrorists.
That is not what the memo says
It does, you lying motherfucker.
at all. It does not.
Is it what the letter says?
That is not what.
Is it what the letter says?
I don't care what the letter says.
You
What I
don't care. You said it was the basis of your memo. You testified under oath before the House of Representatives. The letter was the basis of your memo. Now you don't care about the letter?
The letter and public reports of violence and threats of violence. My memo says nothing about domestic terrorism, says nothing about parents committing any such things. My memo is an attempt to get an assessment of whether there is a problem out there that the federal government needs to
The
resolve.
letter on its face.
The letter to the FBI asking them to figure out if there's a domestic terrorism problem isn't about domestic terrorism to the FBI. What are you talking about, Ted? How could you possibly conclude that?
Says the actions of the parents could be the equivalent to a form of domestic terrorism.
And that is wrong.
And asks the president to use the Patriot Act in regards to domestic terrorism
And you'll note
directed at parents.
And you'll
This was the basis of your memo.
my memo.
The Department of Justice, when you're directing the FBI to engage in law enforcement, you're not behaving as a political operative because a political ally of the president says, hey, go attack these parents because we don't like what they're saying.
Let me clarify this because it could be confusing if you're not like, it's kind of late if you're not following along specifically. Merrick Garland did not write the letter. Merrick Garland's office produced the memo. So the letter was written by the National Association of School Boards to the White House. That's what Ted Cruz is talking about. That's what's in the letter. Merrick Garland's semantic argument is like, well, our memo doesn't say it though, even though he based the memo on the letter. Just in case anybody wasn't following those two distinct documents existing. So it's Merrick Garland's memo, National Association of School Boards letter.
Department of Justice, you did no independent research on what was happening, did you?
The memo has nothing to do with partisan.
Did you do independent research?
The memo has.
Did you do independent research?
The memo has nothing to do.
Okay, you're
with
not
partisan
answering that question.
politics.
You've testified you know nothing about
Won't answer. Did you do independent research?
the violent sexual assault that happened in Loudoun County, even though it's one of the bases in this letter.
I read about it since then.
Okay. You told the
Since
House
then.
last week you knew nothing about it.
Not know at the time. No.
Okay. This week, the court concluded that a 14-year-old girl was violently raped by a boy wearing a skirt in the girls' restroom.
Oh, fuck.
The school district covered it up, released the boy, sent him to another school where he violently raped another girl. The father, who Mr. Hawley just showed you, was the father of the first girl. He was understandably, do you understand why a parent would be upset when your daughter is raped at school, the school board covers it up, and then lies to you and claims there have been no assaults, we have no instances of assaults in our bathroom, and that was a flat-out lie, as the court concluded this week. Do you understand why the parent would be upset?
Absolutely. And
And your Department of Justice is investigating him? Fuck you, Garland. Get wrecked.
any expressions of upset are completely protected by the First Amendment.
Then your motherfucking Department of Justice needs to stop arresting people. And if their rights are being infringed upon by state officers who are stopping their First Amendment protected speech by arresting them, then your Department of Justice should be there protecting the parents, not the school boards, you piece of shit. Fuck you.
Except you just called him a domestic
I
terrorist.
never called him that. That's not
This
correct.
letter calls him a domestic terrorist. You based a direction to the FBI, an official direction from the Attorney General on this letter. And I'll tell you what, the NSBA is so embarrassed of this letter, they've apologized for it and retracted it, but you don't apparently have the same willingness to apologize and retract what you did. Let me ask you.
Oh, shit. All right, let's just a second. Let's get Josh Hawley up because Ted Cruz just referenced it. Here we go.
Senator Hawley.
Wow. Spicy Ted Cruz. Spicy Ted Cruz. You said the full video is a little longer. The full video of Hawley or Cruz? Oh, here we go. Here's the full Josh Hawley video. This is one of the most disgusting displays of government in recent memory. Like, look, government does shit stuff all the time, but when you consider what so there must be stuff at the beginning. Okay, you sent Cruz on DMs. Okay, just a second. This is a full Ted Cruz video. Okay, hold on. Let me get that pulled up real quick. Here we go. Like, look, the government is shit all the time, like I was saying, but like this thing, when you consider what a school board is, right? A school board is the community's oversight of the education locally, because education is supposed to be controlled locally. The idea that there's a national association of school boards is almost offensive to the concept in general, but and the Department of Education is entirely offensive to the concept of what education is supposed to be. Education is supposed to be based in the community where it's happening. Because if you just look at this as a general way, a kid in Chicago does not need the same education as a kid in the middle of the state of Kansas, for example. One probably might need some focus on agribusiness management or something like that. The other one needs to learn, just watch The Matrix to learn how to dodge bullets. Okay. Like there's a vast difference in educational requirements across this country. We keep pretending that there's not. We keep pretending that all kids are similarly situated and we should have a nationalized, standardized thing, but we really should not. Standardized testing isn't all that useful outside of like, and this is why standardized testing is kind of limited to an 8th grade education at the end of the day, because what you need to learn is based largely on your demographics. And I don't just mean race. I don't just mean gender. I mean your physical location, where you want to go, what you want to do. Education is localized for a reason. Again, if you're growing up in the hood in Philadelphia, you're probably not requiring the same education as someone who's growing up in the Hamptons or whatever. But all right, let's get to Ted's first portion here. Just a couple more minutes of Ted Cruz.
For 8 years under Barack Obama, the Department of Justice was politicized.
Wait, no, so it must be at the end of this.
Receive a decision from an ethics advisor.
Here we go.
General, on this letter, and I'll tell you what, the NSBA is so embarrassed of this letter, they've apologized for it and retracted it, but you don't apparently have the same willingness to apologize and retract what you did. Let me ask you something else. A big part of this letter is that they're upset about parents not wanting critical race theory taught.
Uh-oh.
Your son-in-law
Oh, shit.
makes a very substantial sum of money from a company involved in the teaching of critical race theory.
Uh-oh.
Did you seek and receive a decision from an ethics advisor at the Department of Justice before you carried out an action that would have a predictable financial benefit to your son-in-law?
This memorandum is aimed at violence and threats.
I just asked a question. Did you
It
seek an
has
ethics?
no predictable
Did you
effect
seek
on-
an ethics opinion?
It has no
Did you seek an ethics opinion? Judge, you know how to ask questions and answer them. Did you seek an ethics opinion?
You asked me whether I sought an ethics opinion about something that would have a predictable effect on something. This has no predictable effect in the way that you're talking about.
So if critical race theory is taught in more schools, does your son-in-law make more
This
money?
memo has nothing.
If critical race theory is taught in more schools, does your son-in-law make more money? Yes or no?
This memorandum has
Answer the
nothing to do with
question.
critical race
Will you
theory
answer
or
if you
any
sought an
other
ethics
kind of
opinion?
curriculum.
Will you answer if you sought an ethics
I am
opinion?
answering the best I can.
No.
Yes or no? Did you seek an ethics opinion?
This memorandum has
Did
nothing.
you seek an ethics opinion?
This memorandum has nothing to do with.
General,
What?
are you refusing to answer if you sought an ethics
I am
opinion?
telling you that
What a fucking bitch. Just say no, you didn't, because, and then say, no, I did not, because I don't need one, because this memorandum has nothing to do with it, as I'm trying to say. But he won't say no because he knows how bad it looks. If you did this in Judge Merrick Garland's courtroom when he was a judge, he would have cited you for contempt. There is no way a judge asks you a question under oath and you don't answer it after 7 requests.
That there's no possible.
So you're saying no, just answer it directly. You know how to answer a question directly. Did you seek an ethics opinion?
I'm telling you that if I thought there was any reason to believe there was a conflict of interest, I would do that, but I cannot.
Why do you refuse to answer the question? Why won't you just say no?
I'm sorry.
You're not going to answer the question?
I'm sorry. Ask the question again.
Did you seek an ethics opinion?
I'm saying again, I would seek an ethics opinion in.
So no is the answer, correct?
Just say
Senator, your
no.
time is up.
Let the record reflect the Attorney General refuses to answer whether he sought an ethics opinion, and apparently ethics are not a terribly high priority in the Biden Justice Department.
I don't think that's a fair reflection of what I said.
Then answer the question.
Yes or no?
Senator, you've gone way beyond any other senator's time. I think you ought to be at least respectful of other senators at this point.
Mr. Chairman, do you know the answer whether he sought an ethics opinion?
I think you have exchanged that so many times, we know where we stand.
Oh, and of course, Dick Durbin, turbo bitch Dick Durbin, comes in to simp for Garland at the end of the day. What a fucking cunt job these people are. Holy shit. I think we know where we stand. Just say no. Just say no. And why didn't Dick Durbin say, I have no idea? Why didn't Dick Durbin just say, I have no idea if he saw it? I'm not him. God, these fucking people. These people get paid infinity more money than the average American and have infinite opportunities beyond their salaries to make mountains of money. Mountains of money. Any one of these people could pay someone $50,000 to ghostwrite a book based off of audio recordings of them farting in a bathroom, and they would make they would have an advance of $1 million to $2 million on the book. Any one of the senators in this room, and Merrick Garland doubly so. Like, seriously, they could just record anything. Them walking around, some ghostwriter would put together the biography of Merrick Garland and sell it to Simon & Schuster in a money laundering scheme for $2 million advance. No problem. That's what Mike Pence did.
Garland, thank you for being here. Congratulations on your nomination.
Thank you, Senator.
Since
Fuck,
June
no.
of last...
Sorry, this is from February. I got the wrong video. Give me a second. I just realized this is from February 2021. Here we go. My bad. Where's his full questions? I mean, I have 2 of them. I guess this one.
Thanks, Senator.
I guess this one will do. Here we go.
Senator Hawley.
Thank you very much, Mr. Chairman. Attorney General Garland, on October 4th, you issued an unprecedented memo that involves the Department of Justice and the FBI and local.
Like, if you're not paying a lot of attention, like you're doing dishes or whatever in the kitchen, the TV's on in the background, you're like, oh, that Josh Hawley guy's talking. I kind of like the sound of his voice. And you turn around. What do you see? You see like a Pornhub scene going on in the background at first glance. Like, what the fuck is this naked guy doing, kissing Hawley on the mouth? Okay, sorry. This is the dad of the girl who was raped. And we can say it now because a court, I guess, has found it. This is the dad of a girl who was raped in Loudoun County by a boy wearing a dress. And Loudoun County decided to cover it up because of their pro-LGBTQ plus protections. They're trying to protect a class. We don't even know if this boy is a member of the transgender community. We just know this boy was wearing a skirt and used that as a way to get into a bathroom and rape girls. But The school board is protecting them. Merrick Garland is protecting them. All of these people are protecting them. This is the dad who called it out. This is how he was treated for bringing it up at the hearing, by the way. My little girl was raped in your school. Get the fuck down. Put your fucking hands behind your back, you motherfucker. They're 2 seconds away from kneeling on his neck.
School districts, local school boards, nothing like it in our country's history. It was based, you've testified, on this letter from the National School Board Association that we now know the White House was involved in writing. They've retracted the letter. They've apologized for the letter. They say they regret the letter, but you won't retract the memo and said earlier that you have no regrets. And you've defended yourself repeatedly today before this committee by saying, well, you're focused on violence. But now, of course, we've seen the memo from your own Justice Department advising state and local and other prosecutors about all of the different federal causes of action that they can bring against parents that are not about violence, they're about harassment and intimidation. I'm looking here at this memo. It identifies no fewer than 13 possible federal crimes involving harassment and intimidation, including making annoying phone calls. Do you think a parent who makes a phone call to a school board member that she has elected, that school board member deems annoying, should be prosecuted, General Garland?
No, I don't. And the Supreme Court has made quite clear that the word intimidation with respect to the constitutional protection is one that directs a threat to a person with the intent of placing the victim in fear of bodily harm or death. Prosecutors who investigate these cases know the Supreme Court's.
No, they don't. Stop it. Stop lying. No, they don't. They pull this shit all the time.
This is a very famous leading case.
Lucas Gerhard would like to know your location.
Prosecutors do, but parents don't, General Garland. Do you think that a parent who looks at the 13 different federal crimes that you're...
He's getting to a great argument here, which has some strong Supreme Court precedent. It's called the chilling effect on the First Amendment, where government action does not directly infringe on someone's First Amendment rights, but rather creates an environment in which someone would be unwilling to exercise their First Amendment rights for fear of potential government retribution. And that fear can be based on a misunderstanding or even a misstatement or a lack of clarity around the law surrounding the issue. So Merrick Garland issues a letter and says, oh yeah, parents who are unruly at these school board meetings could be subject to 13 different causes of action. Well, some parents who doesn't understand their rights might read that letter and go, oh, I better not go to the school board meeting then, because if I say something that could be deemed as annoying or embarrassing to one of these people, then that might be me getting a federal charge. And let's be real. Even no matter what Merrick Garland says about prosecutors knowing the difference, you could still catch a charge. You could still get arrested for the day. You could still have your face put across all the newspapers as this guy's face of him getting arrested by law enforcement. You can get a bogus charge. You might win that charge, but guess what? Your face is going to be on. Oh, you wouldn't want your face on the front page of the newspaper for being unruly during a school board meeting. That wouldn't look very good in the local community paper, would it? Right? People might look at you sideways when they see you at the grocery store the next time.
Your Justice Department has identified they might be subject to and prosecuted for, like making annoying phone calls. Do you think that they're going to feel that they're welcome to speak up at a school board meeting? How about this one? They could be prosecuted for using the internet, I guess that would be Facebook, in a way that might cause emotional distress to a victim. Is that a crime of violence?
Senator, I haven't seen the memo that you're
Why
talking
haven't
about,
you?
and I don't, even from the description, it does sound like it was addressed to parents. But if you...
No, it wasn't addressed to parents. It was addressed to prosecutors. That's the problem. Why haven't you seen the memo?
I don't know why I haven't. I don't look at I do not get every memo that every U.S. attorney sends out. But if you're...
Wait a minute. I just want to be sure I understand this. This is a memorandum that collects 13 different federal crimes parents could be charged with. It has United States Department of Justice on the top of it. And you're telling me you haven't seen it?
Who's the memo from, Senator?
The United States Department of Justice, United States Attorney for the District of Montana.
I have not seen a memo from the District of Montana.
Not high enough priority for you?
It's not. That's not the question. I don't.
It is the question. Answer my question. Is it?
You know what? Josh Hawley was a super cuck on a different issue that I don't even remember. You can go back. It was I think it was a speech issue or something a while back about pornography or whatever. It doesn't matter. When he's on, man, he is on.
Is it not a high enough priority for you when you're threatening parents with 13 different federal crimes? These aren't crimes of violence. You've testified today. You're focused on violence. That's not what your U.S. attorneys, they work for you. That's not what they're saying. You haven't seen it because it's not a high enough priority, or what?
Question of priority. No one has sent me that memo, so I haven't seen it.
What do you mean no one has sent you the memo? You run the United States Department of Justice, do you not?
There are 115,000 employees of the Department of Justice.
Indeed, and you are in charge of every one of them. And this was a sufficiently important case that you...
If Merrick Garland was prosecuting Facebook, Mark Zuckerberg would be answering these same questions from Merrick Garland. The dude, this is the best part about this. The dude is a slimy fucking weasel, and he knows, and everybody in that room knows that he would be asking these exact same questions to the CEO of a company, no matter how fucking big it was. And first of all, there are 115,000 employees in the Department of Justice. How many of them are the district or the attorneys for the Department of Justice in Montana? What, like 3? How many U.S. attorneys in Montana? And it's one office in Montana. Like 3 is an understatement. That's a joke. But this is...
You issued a memo. You, over your signature, issued a memo involving the FBI and the Department of Justice in local school boards, local school districts. Your U.S. attorneys are now threatening prosecution.
That's not the right page, Josh.
With 13 different crimes, but it's not a high enough priority for you. It got lost in the mix.
I'll send again. I've never seen that memo.
That's what concerns me, General Garland.
Well, it wasn't sent to me. I hope you will assure your constituents that what we are concerned about here is violence and threats of violence.
That only leads me to conclude, General Garland, all I can conclude from this is either that you're not in control of your own department.
Remember, just a little bit ago, Merrick Garland said his prosecutors know the difference, right? That was the argument that he made. But then again, this is one of his prosecutors sending out a memo that he has no idea of. He can't possibly know that these prosecutors know the difference. He hasn't even seen it. He doesn't know what's in there.
Or that, more likely, what I think to be the case is that you knew full well that this is exactly the kind of thing that would happen. When you issued your memo, when you involved 100%. The Department of Justice and all of its resources, and the FBI and all of its resources, in local school boards and local school districts, you knew that federal prosecutors would start collecting crimes that they could use against parents.
Yep.
You knew they would advise state and local officials that these are all of the ways parents might be prosecuted. You knew that that was the likely outcome. And that's exactly what's happened. And we're talking about parents like Scott Smith, who's behind me over my shoulder. This is a father from Loudoun County, Virginia. Here he is at a school board meeting. He was forcibly restrained. He was assaulted. He was arrested. Why? Because he went to an elected school board meeting. He's a voter, by the way. He went to an elected school board meeting to raise the fact that his daughter was assaulted, sexually assaulted, in a girl's restroom by a boy. This is what happened to him. Now, you testified last week before the House that you didn't know anything about this case. I find that extraordinary because the letter that you put so much weight on, the letter that's now been retracted, it cites this case. It cites Mr. Scott's case directly. Whoops. There's a news article cited in the letter. It's discussed in the letter, but you testified you just couldn't remember it. Maybe this will refresh your memory. Do you think people like Scott Smith, do you think parents who show up to complain about their children being assaulted ought to be treated like this man right here?
Parents who show up to complain about school boards are protected by the First Amendment.
They don't look protected by the First Amendment, and your memo does not look to protect parents under the First Amendment.
Do you think that they ought to be prosecuted in the different ways that your U.S. attorneys are identifying?
If what they're doing is complaining about what the school board is doing, policies, curriculum, anything else that they want to, as long as they're not committing threats of violence, then they should not be prosecuted. and they can't be.
Let me ask you about this. Several of my Democrat colleagues have today, just today in this hearing, multiple times have compared parents who show up at school board meetings, like Mr. Smith here, have compared them to criminal rioters. You think that's right? You think that a parent who shows up at a school board meeting, who has a complaint, who wants to voice that complaint, and maybe she doesn't use exactly the right grammar, you think they're akin to criminal rioters? Do you agree with that?
In real quick, in Minnesota, there's a school board that requires you to dox your name and address to speak on the record. And they had a parent there who tried to bring up some issues to the school board. They said he was not allowed to speak without providing his address. And after much back and forth, he turned away from the microphone to talk to the away from the microphone. He said his address so that it wouldn't be on the record. And the lady read his address out loud into her microphone so that it would be on the record. It's absolute insanity. This notion that you can go to a school board and complain. No, you can't. I mean, you're supposed to be able to, but no, you can't.
I do not, and I do not remember any senator here making that comparison.
Oh, really? These people are just like the folks who came here on January 6th and in the riot at the Capitol?
I don't think they were referring to the picture that you're showing there.
Well, I certainly would hope not, but they were referring to parents who go to school board meetings. Mr. Smith is a parent who went to a school board meeting. I'll leave it at this, General Garland. You have weaponized the FBI and the Department of Justice. Your U.S. attorneys are now collecting and cataloging all the ways that they might prosecute parents like Mr. Smith because they want to be involved in their children's education and they want to have a say in their elected officials. It's wrong. It is unprecedented, to my knowledge, in the history of this country, and I call on you to resign.
Nice. Good work, Hawley. Good work, Hawley. Calling on him to resign. I heard Tom Cotton. Let's check Tom Cotton real quick. I know there's some people, I've seen a couple of people in the chat too, who think that these don't matter. Nothing will ever come of this. Nothing directly comes of this. I mean, it's not always direct. It's not always a direct response that you get. And that's not always what you need to be after. The fact that people talk about this, that these clips make it onto Fox News, that they'll make it here and there, that they'll get disseminated out. It creates general disapproval with what's going on, and it can be a force for change that may not be recognized directly. I actually disagree with people who think that these hearings are completely pointless. If they were completely pointless, like these guys base their political careers and the careers of their opponents on these types of meetings. They're the people who directly are impacted by elections and by public sentiment. If they think they're important and keep doing them, I think they might have some level of importance personally. Now, it's not always tangibly relatable to a specific thing, but having these things is, in my opinion, I like it. I think it's outrageous. I think it's useful. But that's me. You guys are free to disagree, of course. If you do disagree, you have to shove your hand in a garbage disposal. I mean, but you are free to disagree. You have that freedom to disagree, but the consequence of your First Amendment right to disagree with me is that you have to put your hand in the garbage disposal and turn it on. I mean, look, if you don't want the consequence of putting your hand in the garbage disposal and turning it on, you just maybe keep it to yourself that you disagree. Like, you just don't disagree with me, right? Like, that's simple. You have all the freedom in the world to disagree. You just have to put your hand in the garbage disposal. And that is the exact argument of every stupid motherfucker on Twitter who talks about, oh, you don't have free speech. You got consequences for it. I mean, you have your free speech, but you have consequences for your free speech. Oh, yeah. Well, you chose those consequences. No, you didn't. No, you didn't. 10 years ago when you said the N-word on Halo 2 and someone recorded it, you chose the consequence that you'd be fired from your job now. You chose that consequence. No, you didn't. Stop it. Here we go. This is Tom Cotton.
This directive sicking the feds on parents at school boards across America. When you crafted that October 4th memo, did you consult with senior leadership at the FBI?
My understanding was that the memo or the idea of the memo had been discussed with the FBI before. It got
Did anyone at the FBI express any doubt or disagreement or hesitation with your decision to issue that memo?
No one expressed that to me.
No one,
To me, no one expressed that to me. No.
because a lot of them have contacted us and they said they did, Judge.
I'm sorry.
A lot of FBI officials have contacted my office and said that they oppose this decision.
Well, I doubt any of them spoke to me about it because I didn't speak to no one.
All right,
made that
all right.
to me.
Judge, you've repeatedly dissembled this morning about that directive. For instance, about the National Security Division. Chuck Grassley asked you a very simple question, why you would sick the National Security Division of the Department of Justice on parents. John Cornyn asked you the same thing. You said it wasn't in your October 4th memorandum, it was in another office's memorandum. It wasn't another office's memorandum, Judge. It was in a press release from your office, right here in front of me, October 4th, 2021, for immediate release. You're going to create a task force that includes the National Security Division. What on earth does the National Security Division have to do with parents who are expressing disagreements at school boards?
Nothing in this memorandum or any memorandum is about parents expressing disagreements with their school boards. The memorandum makes clear that parents are entitled and protected by the First Amendment to have vigorous debates. We don't, the Justice Department is not interested in that.
Real quick, let's do this. Pretty sure I've read this before, but real quick, here's that memo. Directed to the FBI, the Executive Office for U.S. Attorneys, Assistant Attorneys General, Criminal Division in the United States, from the Attorney General Merrick Garland. In recent months, there's been a disturbing spike in harassment, intimidation, threats of violence against school administrators, board members, teachers, and staff who participate in the vital work of running our nation's public schools. While spirited debate about policy matters is protected under our Constitution, that protection does not extend to threats of violence or efforts to intimidate individuals based on their views. Threats against public servants are not only illegal, they run counter to our nation's core values. There's no mitigating language here. Those who dedicate their time and energy to ensuring that our children receive a proper education in a safe environment deserve to be able to do their work without fear for their safety. The department takes these incidents seriously and is committed to using its authority and resources to discourage these threats, identify them when they occur, and prosecute them when appropriate. In the coming days, the department will announce a series of measures designed to address the rise in criminal conduct directed towards school personnel. Coordination and partnership with local law enforcement is critical to implementing these measures for the benefit of our nation's nearly 14,000 public school districts. To this end, I'm directing the FBI, working with each U.S. attorney, to convene meetings with federal, state, local, tribal, and territorial leaders in each federal judicial district within 30 days of the issuance of this memorandum. These meetings will facilitate the discussion of strategies for addressing threats against school administrators, board members, teacher, and staff, and will open dedicated lines of communication for threat reporting, assessment, and response. The department is steadfast in its commitment to protect all people in the United States from violence, threats of violence, or other forms of intimidation or harassment. So remember that this memo directed the FBI to work with U.S. attorneys to create memos that he would later go on to say they never sent it to me, right? That was the memo that he was talking about from Montana. Well, I've never seen the Montana memo. His memo directs those memos to be created to disseminate to state and local law enforcement to tell them what kind of criminal activity to look for. And yet no one sent it back to say, hey, here's our draft memorandum. We worked with the FBI. We're looking for sign off from the home office of the DOJ. What do you think? Considering this is U.S. law we're talking about, we're not talking about Montana law. Let's see if the in-house counsel at the DOJ agrees with our assessment. Do we need to mitigate where, this is your baby that we're engaging in, but they just gave them complete autonomy to generate memos and no one was supposed to send it to anybody. There's no review. Again, if Merrick Garland were the CEO of Target and in some Target district out in Montana, had created some memorandum that would violated federal advertising guidelines, the CEO of the company would be answering the questions that Merrick Garland can't answer. Say, oh, you mean they didn't send it to your central marketing office for review of this advertisement? You're a big company with lots of resources. Why didn't you do that? These would be the questions.
Question at all. It is
Okay, so even in that case, what
violence.
is the National Security Division, Judge? These are the people that are supposed to be chasing jihadists and Chinese spies. What does the National Security Division have to do with parents at school boards?
This is not, again, about parents at school boards.
Yes,
This
it
about
is.
threats of violence.
Okay, let me turn to that because you've said that phrase repeatedly throughout the morning. Threats or violence and threats of violence. Violence and threats of violence.
Yeah.
We've heard it a dozen times this morning. As Senator Lee pointed out, the very first line in your October 4th memorandum refers to harassment and intimidation. Why do you continue to dissemble in front of this committee that you are only talking about violence and threats of violence when your memo says harassment and intimidation?
Senator, I said in my testimony that it involved other kinds of criminal conduct. And I explained to Senator Lee that the statutory definitions of those terms and the constitutional definitions of those terms involve threats of violence.
Okay, let's look at one of those statutes you cited.
Yeah.
Section 223.
Yeah.
That statute covers the use of not just telephones, but telecommunications devices to annoy someone. So are you going to sick your U.S. attorneys and the FBI on a parents group if they post on Facebook something that annoys a school board member,
Well, the
Judge?
answer to that is no. And the provision that I was particularly drawing to his attention was 2261A, which was to engage in.
I wasn't talking about 2261A. I know you mentioned that. You also mentioned 223. That's what I mentioned.
Yeah, but the
Okay,
only kind.
Judge, you also told Senator Klobuchar that this memorandum was about meetings and coordination.
Yeah.
Meetings and coordination.
Yeah.
Well, I have in my hand right here that I'll submit to the record a letter from one of your U.S. attorneys to all of the county attorneys, to the attorney general, to all sheriffs, to the school board association of his state, in which he talks about federal investigation and prosecution. It's not about meetings, it's not about coordination, it's about federal investigation and prosecution. Did you direct your U.S. attorneys to issue such a letter?
And the important thing here is you may never be prosecuted, but people know that if they go to a school board meeting and get loud or get worked up or say something maybe a little controversial or call the school board meetings rape apologists or something like that, they might not be arrested. But are they suddenly being investigated by the Federal Bureau of Investigation, the people who track down bomb dealers, the people who crack down on terrorists, the people who go after people with plans to assassinate public figures, that the FBI is going to be looking into their lives because they went to a school board and said, you guys are a bunch of bitches. Suddenly the FBI will be watching you, will be monitoring your phone calls. They won't record the phone calls. Of course not. That would require a FISA warrant. They're not going to get that, but they'll record all the numbers that you called. Maybe they'll take a look at your bank account, right? See who you're writing checks to. Maybe they'll just go ahead and ask Google for your search history while you're at it, right? Well, I mean, maybe you have ties to an extremist group like the Proud Boys. What do they know? They got to figure that out. You're under investigation now by the FBI because you said something wrong at a school board meeting.
I did not. I have not seen that letter.
It's got 3 pages. It's got 3 pages of spreadsheet about all the federal crimes that a parent could be charged with, to include the ones you cited. Did Maine Justice make this spreadsheet, Judge?
I don't have any idea. My memorandum speaks specifically about setting up meetings, and I'll just read it again, convene meetings.
Judge, we've all read your memorandum.
Well,
we've also heard you dissemble about your memorandum. I have, and the record now shows, one of your U.S. attorneys sending out a letter about federal prosecution investigation and list in detail
because of the memorandum
which could be prosecuted. Judge, you've talked a lot about intimidation and harassment. Have you issued a memorandum like your October 4th memorandum about the Black Lives Matter riots from last summer?
Did
You're
you?
talking about the summer of 2020? In the summer of 2020, there
A
were
lot of crimes committed. People haven't been
there were a
charged
lot
for
of
those crimes yet.
prosecutions, and they were under the previous administration.
Okay, Judge, what
They had
about
a lot of
this?
prosecution.
It is no doubt even though parents at school boards aren't within federal jurisdiction, there's no doubt that federal officials are. You keep saying senators. Have you started an investigation into the harassment of Senator Kirsten Sinema in a bathroom? Because she won't go along with the Democratic Party's big tax and spend agenda? That is a sitting United States senator being harassed in a bathroom.
I don't know whether the senator has referred the matter to the Justice Department or not.
He's dumbstruck. He knows he has limited time. He's just like, motherfucker.
You've cited as the basis for that directive the National School Board Association's letter of September 29th. Was that directive being prepared before September 29th, before the School Board Association letter was issued?
I don't believe so. Certainly, I didn't have any idea.
So it was only prepared okay, I think that answers the
I
question.
already answered that
So
question.
you
before.
keep citing the school board letter and news reports.
Right.
One of the news reports cited in that letter, which you presumably mean, is from Loudoun County, Virginia.
No, that's
Scott-
not. That is not what I was talking about.
Well,
I was talking
you
about-
keep citing news reports, and
Yeah.
that's the most prominent news report that anyone in America has seen. That refers to Scott Smith, whose 15-year-old daughter was raped. She was raped
Holy
in a bathroom by a boy wearing girls' clothes, and the Loudoun County School Board covered it up because it would have interfered with their transgendered policy during Pride Month. And that man, Scott Smith, because he went to a school board and tried to defend his daughter's rights, was condemned internationally. Do you apologize to Scott Smith and his 15-year-old daughter, Judge?
Senator, anyone whose child was raped is the most horrific crime I can imagine, and is certainly entitled and protected by the First Amendment to protest to their school board about that.
But he was
He
cited
wasn't.
by the School Board Association
That's fine,
as a
but that's
domestic
not-
terrorist, which we now know that letter and those reports were the basis for your.
No,
This
no,
is
Senator,
this is
that's wrong.
shameful. Judge,
That's-
this is shameful.
that's-
This testimony, your directive, your performance is shameful.
That's not.
Thank God you are not on the Supreme Court. You
That-
should resign in disgrace, Judge.
Damn.
General Garland, do you want to complete your answer on?
Okay, I wasn't sure there was a question there, but let me be
There
clear.
wasn't.
The,
It's
the
just a
news reports
statement.
I'm talking about were not the news reports in that letter. They were other news reports that everybody.
Very important. Yeah, he didn't apologize for it. He didn't apologize for it. Now, not that Merrick Garland raped the daughter or arrested the dad, but hey, you know what? Here's how you do that, right? He's like, look, we were given this letter. At the time the letter was written, we were unaware of this incident. However, it has now come out that there was serious misconduct in Loudoun County, Virginia, that there was misconduct going all the way up to the superintendent of the school. A judge has determined that they were covering it up, and that is absolutely inappropriate. And of course, we apologize for using this as part of the basis for this letter, but it's not the only basis for the memorandum. We're actually basing it on several other facts. Like that's how you handle this stuff. This isn't that hard. Like everybody knows that Merrick Garland didn't send a boy into the bathroom to rape the daughter and didn't send the state authorities to arrest the dad. But you can apologize for mischaracterizing these events or for utilizing mischaracterized events without making any sort of correction on the record. And for this guy being internationally mislabeled. By the way, where's all the fake news takedowns from YouTube and Twitter? Where's all that? Where's all the fact checkers on that one? On this guy lying about his daughter being raped in a he didn't lie. Shit.
Everybody here has heard about, subsequent reports that everybody has heard about. There is nothing in this memorandum, and I wish if senators were concerned about this, they would quote my words.
Why?
This memorandum is not about parents being
They are quoting your words. They're in the memorandum.
able to object in their school boards. They are protected by the First Amendment. As long as there are no threats of violence, they are completely protected. So parents can object to their school boards about curriculum, about the treatment of their children.
They can't. They actually can't, Merrick. That's the problem. They can't go do it.
About school policies, all of that is 100% protected by the First Amendment, and there is nothing in this memorandum contrary to that. We are only trying to prevent violence against school officials.
What violence has happened against a single school official? Do we have a single school official? Do we have one school official who has reported violence against them that supports any of this? Do we have one? Let's see. Let's see. Merrick Garland. I got one more that I heard was good. Check it out. I'm sure there are more that are good. This is all still pretty new, but let's get to Chuck Grassley. Sorry, sometimes you need a little red meat.
Thank you, Chairman Durbin. This committee has a constitutional obligation to ensure that the department complies with the laws that we write and execute those laws according to our intent. In the performance of our constitutional duty, we write letters seeking answers and records from the department and its component agencies to better understand what they're doing. Likewise, the entire executive branch, not just DOJ, has an obligation to respond to congressional oversight requests. Today, I can say with confidence that under General Garland's leadership, the department has failed across the board to comply with this committee's Republican oversight request. And I appreciate very much Chairman Durbin pointing out a letter that he and I wrote 5 months, haven't received an answer. If my name being on that letter has any reason it hasn't been responded to, I'll take my name off of that letter. In contrast, General Garland, you've provided Democrat colleagues with thousands of pages of materials. Moreover, President Biden has politicized and inserted himself into the department policymaking, notably directing the end of compulsory process for reporter records in criminal leak investigations, and most recently, inserting himself when he said the department should prosecute anyone who defies compulsory process from the January 6th committee. At your confirmation hearing, I read to you what I told Senator Sessions.
Okay, Chuck. Come on, get to it. Whew, you are old, buddy, and it's showing.
At his confirmation hearing for being Attorney General, this, quote, if Senator Feinstein, who then was ranking member, if Senator Feinstein contacts you, do not use this excuse, as so many people use, that if you are not a chair of a committee, you do not have to answer the questions. I want her questions answered just like you would answer my questions. End of quote that I gave to Senator Sessions. So you said to me at your hearing, quote, I will not use any excuse to not answer your questions, Senator, end of quote. You have failed to satisfy that statement. Example, I've asked the department for records relating to Hunter Biden's October 2018 firearm incident, where his gun ended up in a trash can near a school. Now that's a firearm.
I didn't even know about this. Wait, Hunter Biden dropped his own gun in a garbage can by a school? What is this?
Incident. Your ATF used the Federal Freedom of Information Act to refuse producing those records when that law doesn't even apply to the Congress. I've also asked for information relating to Chinese nationals linked to the communist Chinese regime that are connected to the Biden family. One individual, Patrick Ho, was not just linked to Chinese regime, he was apparently connected to that country's intelligence service. Hunter Biden reportedly represented him for $1 million. Now, even though the department already made public in court filings that DOJ possesses FISA information relating to Patrick Hall. In response, you stated, quote, "Unfortunately, under the circumstances described in your letter, we are not in a position to confirm the existence of the information that is sought if it exists in the department's possession." Well, let me emphasize, well, you already made it public in a court filing. So you're telling me you can't even confirm its existence. Now, with respect to the criminal investigation of Hunter Biden, Senator Johnson and I wrote to you twice this year.
Watch Merrick's glasses while he has the mask on as they fog up.
Regarding a person named Nicholas McQuaid. Mr. McQuaid was employed at a law firm until January 20th, 2021, when he was hired to be then acting Assistant Attorney General for the department's criminal division. Before he was hired, he worked with Christopher Clark, who Hunter Biden reportedly hired to work on his federal criminal case a month before President Biden's inauguration. Now, the department hasn't disputed any of these facts. However, you refuse to confirm whether Mr. McQuaid recused from the Hunter Biden case. That seems to be a pretty simple thing to say one way or the other. The son of the President of the United States is under criminal investigation for financial matters. A senior attorney under your command has apparent conflicts with that matter. Your refusal to answer just threshold questions cast a very public cloud over the entire investigation, a cloud that you should easily do away with if you were just a little bit transparent. When I placed holds on your nominees for the department's failure to comply with Republican oversight requests, I said either you run the Department of Justice or the department runs you. Right now, it looks like the Department of Justice is running you. Since your confirmation in less than a year,
Does Chuck ask any questions?
the department has moved as far left as it can go. You've politicized the department in ways it shouldn't be. Case in point, your infamous school board memo.
Oh, here we go.
You publicly issued this memo merely 5 days after the National School Board Association wrote a letter to President Biden. Now, incredibly, they asked the department to use the Anti-Terrorist Patriot Act against parents speaking their minds to local school officials. The School Board Association has since apologized for that letter, but not before the department relied on their letter to mobilize federal law enforcement in state and local matters. Meanwhile, actual violent crime is on the rise in the country.
Okay, I don't want to hear Chuck Grassley just like slowly bitch at Merrick Garland. That got real boring to me. That one is I'm sure he was saying good stuff. I couldn't even follow along. I just didn't care. Just one more that I have a feeling is probably decent. Here we go. I think this one will be a little bit different. Now, it's not this. I would not do this to you. I am not this kind of rude man. I am not awful. I would not do this.
Mr. Attorney General, we had promised you a 5-minute break at 11:30. We can either take it right now, or I can have Senator Lee and Coons ask. Up to you.
I'm happy to go ahead with Senator Lee and Coons.
Let's proceed. Senator Lee.
Thank you, Mr. Chairman. Thank you, Attorney General Garland, for being here. Mr. Attorney General, I've been concerned in recent weeks by some steps that have been taken by the Biden administration, steps that I fear represent a significant amount of overreach. 7 weeks ago, you had President Biden giving a speech in which he promised to enlist the assistance of corporate America, all of corporate America, with more than 99 employees, in firing people who don't get vaccinated. Now, I'm vaccinated. I've encouraged everyone close to me to get vaccinated, but I don't think it's the role of the federal government to do that. He's threatening to cripple employers by imposing absolutely punishing fines on them. And they're now doing his dirty work, even before this act of overreach has been reduced to an order that could be litigated. Litigation that I believe would end the same way Youngstown Sheet and Tube versus Sawyer ended.
Ooh.
And
If you want to figure out how Youngstown ended, the government lost.
now, about a month after that, we had your October 4th memorandum in which you direct the Department of Justice and the FBI to intervene in what, as far as I can tell, is a state and local issue. That is a series of issues involving how parents advocate for their children with their local school boards. And I also believe that doing that through the Department of Justice, doing it in the way that you did it, directing the assistance, enlisting the help of all 94 U.S. attorneys. Therefore,
I will not play videos at 1.5 speed ever. I don't think it helps. I don't like it. It changes the way it sounds. No.
every satellite office of the Department of Justice nationwide, you do it in a way that I think has a natural tendency to chill free speech in this area. I question seriously the role of the federal government in protecting people at local school board meetings from their neighbors. It is, after all, most of the time, state law, not federal, that's at play when there is criminal activity. Federal crimes are a subset of crimes generally. So you've referenced several times today that your letter covered only violence and threats of violence. And yet the very opening line of your memo says, in recent months, there's been a disturbing spike in harassment, intimidation, and threats of violence against school administrators, school board members, teachers, and staff who participate in the vital work of running our nation's public schools. You refer to this over and over again, and it's a pretty broad statement. I believe this has a tendency to chill free speech that is exercised at the state and local level, typically by neighbors, by parents to local school boards. In hindsight, would you agree that a natural consequence of your memo could be chilling free speech, protected speech by parents protesting local school board policies?
He's not going to answer this.
The memo is aimed only at violence and threats of violence.
Not
It
true.
states on its face that vigorous debate is protected. That is what this is about, and that is all this is about.
What about harassment and intimidation? Are those federal crimes?
They are federal crimes.
What, are you referring to like witness tampering, intimidation under 18 USC 1512, or what?
18 USC 2261A, which makes it a crime, intent to injure, harass, or intimidate, placing a person in reasonable fear of serious bodily injury through communications over the internet. Likewise, 47 USC 223A, making telephones calls with intention to harass. Now, I want to be clear, though, that those only are within, I take your point, those are only within what is permitted by the First Amendment.
But you didn't say that, did you? You didn't say that. Remember, this is a federal memorandum, and it does not say this. They knew this would come out. Have you ever seen a one-page federal memo? These things are usually fucking voluminous. They've got pages and pages and pages of bullshit and citations and charts. One page, 5 paragraphs, and they didn't think to put in within the bounds of the First Amendment. I mean, normally there would be an entire section that would talk about making sure to respect the bounds of the First Amendment and how you go about doing that, limiting these things to specific threats of violence or specific things that are definable under U.S. law, such as state v. whatever, U.S. v. this, U.S. v. that. That's how you would write this memo. That's how I would have to write this memo if I worked for the Department of Justice. You would provide guidance on what you're talking about. That memo was shit out in an hour.
And the Supreme Court has been clear about that.
And that was intentional, by the way. Leaving it vague is the chilling effect Mike Lee is talking about. That was the purpose. They wanted to, I don't think they're actually going to deploy the FBI against most parents. If they did, that parent is going to win a shitload of money if they can ever determine it, because under 18 USC 1981 or 1983, they've got a claim against the government for doing this shit. As Melinda would say, under color of law, when they don't have a legal authority to do so. It would be glorious, but it's not about prosecutions. It's about silence. That's the chilling effect.
Too. In the Virginia versus Black case, the court explained when intimidation is not protected by the Constitution, and that is when it is made.
Why didn't you cite it in the memo? You could have just cited it in the memo.
With the intent of placing the victim in fear of bodily harm or death. So that's what we're concerned about
That's a legal memo for the Department of Justice without a single legal citation on it.
here.
Well, and one of the things that concerns me is, we've got 17 attorneys general, led by Attorney General Todd Rokita in Nevada and joined by
Todd Rokita? Who's that guy?
a total of 17 attorneys general, including Sean Reyes, the fantastic Attorney General of the state of Utah. And they've weighed in and they've said that there is not a barrage of accusations. There's no unusual flood of accusations of threats of violence against school board members. Nothing unusual, nothing that they can't handle at the state and local level. Normally, things like this against state and local officials involving state and local government entities like school boards are not federal. Now, in response to a series of questions before the House Judiciary Committee, including some questions asked by Congressman Jim Jordan from Ohio, you were asked your factual predicate for your October 4th memorandum and for your conclusions in this regard. You answered before that committee that your factual predicate for that was the October 22nd memorandum from the National School Board Association. The National School Board Association has been mentioned, has since withdrawn that memo, and yet you said that was the factual predicate. Given that that was the factual predicate and that it's rescinded its memo saying that there was no justification for some of the language that they used in that letter, will you rescind your memo?
Senator, best of my recollection, I said that the impetus for the letter, for my memorandum, was that letter and also reports of this kind of activity.
What reports?
I said again that at the time that they were news reports that had been published, and I think that some of the other senators here have described some of those news reports, and we've certainly seen subsequently more news reports and more statements by board members of threats to kill them.
Yeah, because board members wouldn't exaggerate. Everybody has. Oh my God! I'm radicalized on death threats. I am so far radicalized on death threats. I don't believe that anybody in the history of Earth has ever actually been death threatened. That's how often people fucking lie about death threats, because it's the quick go-to. Oh, he threatened to kill me. No, he didn't. No, he didn't. No, she didn't. No, they didn't. No, anybody. The only one I believe is that the government does. I'm so far radicalized on this because everybody, I've received several death threats, post them. And it's never a death threat. Guess what? Some guy probably went to a school board county and says, you all should be hanged for your activity. This is insane. And they're like, that's a death threat. That's not a death threat. That's not even close to a death threat. That's not legally a death threat. It's not even questionable that is not a death threat. Say, you know what? I hope when you die, when you're on your deathbed and you're dying, you look back on this and you realize what you did. That's not a death threat. That's not even close. None of this shit is death threats. None of these fucking people have been threatened with death. Not one of them. I'm so tired of it. It never happens. They never produce a receipt. And you know why they don't produce a receipt? Because when they do, everybody goes, it's not a death threat, without fail, every single time. I'm so tired of hearing death threats.
Congressman Chip Roy of Texas raised in that same hearing the issue of a 14-year-old girl in a school bathroom being sexually assaulted in Loudoun County. And you indicated in response to that you weren't aware of that. And in the 6 days before you testified before the House Judiciary Committee, have you become familiar with the publicly reported details of that case?
Yes, I have read about the case. Yes.
If you were unfamiliar with the supposed instances of threats of violence and intimidation that the National School Board Association cited in the letter, then how did you determine that intervention by the FBI and the DOJ was necessary, that was the right approach?
So the right approach in the letter is to meet with local law enforcement. That's what we've asked for, is to meet, to assess the situation, to see what their needs are, to strategize, and to open lines of communication. Now, I'm hopeful that many areas of local law enforcement will be well able to handle this on their own. But this is what the Justice Department does every day. We consult with our local and state partners and see whether assistance is necessary. And of course, we continue to have our own federal responsibilities with respect to communications by the internet, on social media, on telephone, through the mail. But I'm hopeful that we will not be needed in this area, that our state and local partners will be able to handle these threats.
My time's expired.
Mike!
I just want to state for the record as I close that my staff and I went through every news source raised by the National School Board Association. There was no explicit death threat. And I choose here to reiterate my concern that not every outburst or expression of concern by neighbors, among neighbors at a local school board meeting warrants a federal investigation. Certainly doesn't warrant the involvement of 94 U.S. attorneys in a way that threatens, intimidates, and tends inevitably to chill First Amendment activity. Thank you.
I thought that was a little weak by Mike Lee. I usually like him a little more. He only managed to get 3 questions out. A little bit disappointing, to be honest. A little bit disappointing from Mike Lee, but you can't bat 1,000 unless you're me. And so therefore, Mike Lee will have to, maybe I'll give him lessons sometime on how you bet 1,000. If you just try betting 1,000 like I do, then this wouldn't happen, Mike. This wouldn't happen. Okay. All right. Let's do super chats. Let's wrap up the show. Let's do justice chats as well. Here we go. And we will go over to Twitch for a movie tonight. I'm not sure exactly what movie, but we will have a movie tonight. And tomorrow night I will be on Twitch as well after the show, and we should be having. So I think I'll probably be playing Diablo 2. I'm trying to catch up to Krigler so I can meme. I've got a meme sorceress build in the making, playing Charged Bolt Sorceress, which is Adam Krigler doesn't believe that it exists, and I'm going to be memey and annoying playing along with him. So that's the whole purpose of it. Angry Baneling, I have determined that your taste in movies is bad, so I'm not sure if we're going to watch The Unborn yet. We'll see. All right. Where are we? Philabooty says, damn it, Nick, shame on you for making fun of this cripple. I thought you were hamming it up with the lips, but fuck me, you were tame. Fuck Russell, but not because he's a cripple, fuck him because he's logically retarded. Russell Greer it's not even that he's stupid. That's not what makes Russell Greer worthy of mockery and shame. Russell Greer is quintessentially a bad person. Russell Greer stalks and bothers women routinely over and over again, not just high profile women with the ability to have security and barriers between him and them. He goes after local strippers and stuff like that. Dude is shady. Dude is gross. Dude is fucking terrible. Like, he's just a bad person. And again, he utilizes the legal system consistently to try and punish people for their very reasonable, which is why he doesn't win. He's nasty. And that's why fuck Russell Greer. It has nothing to do with his facial deformity or his stupidity or his bad legal takes. And those are just funny. Those are just funny dressing on the fact that he's a bad person. In my opinion. Chuck Ross says, I tried to find Angel's Envy finished rye, but it isn't within driving distance. Do you have any other recommendations? I know my local ABC has Whistle Pig and Glenlivet. I'd go with Whistle Pig over Glenlivet. Glenlivet's fine. Glenlivet 12 is a great inexpensive scotch, like for just, it's very run of the mill bog standard scotch. But I'd go with a Whistle Pig. If you can't get an Angel's Envy finished rye, but if you're in the $100 range, you can look for a Talisker 10-year. Don't get a Talisker Storm. That's trash. Talisker 10-year is really good. A Bowmore. If you can find a Bowmore 15 Darkest, that is one of my favorite scotches. Very, very good. Okay. Hope that helps. President-elect Austin M says the best that the prosecution could come up with as an expert witness is an intro to and basics of law enforcement teacher from some community college. Printer God says, how much would it take to make you drink an entire bottle of Applejack on stream? I don't like drinking for money and stuff like that. I don't want to drink that much. I didn't feel great after drinking a lot of that Boondocks. This was 2 days of the Boondocks, guys. That's too much. That's too much. Most of it was the first day. That's 60% alcohol. That's too much. I'm not a heavy drinker like that. Uncivil law and good logic can take turns vomiting over that. No, thank you. No, thank you. Red Guy says, at least it's not the black spot. If it is, you get sued by Amber Heard. Aw. Joshua Dingle says, Nick, try Dingle Irish whiskey. Oh, if I can find it, I'll try it. I did get this. Look at this thing. That's a bottle if I've ever seen one. This is the Hague Club single grain Scotch whiskey. So there's single malt, right? And then there's single grain, which it uses one grain instead of a multi-grain mash. So yeah. Very interested to try this guy. Looks like a massive cologne bottle. Hopefully it doesn't taste like a massive cologne bottle. Corn Bob says, I'm not a heavy drinker. Check out my hundreds of bottles here. I have 3. I have 3 bottles of whiskey right now. Arlanius says, is there a point where you can't sue anymore because Greer could make a case for the president? No, your right to sue is absolute. However, there is a term called a vexatious litigant. You can be ruled a vexatious litigant in a particular district or court, I believe. I don't think it extends outside of that, where if you attempt to bring another action in that court, that you would have to basically make a showing of good faith prior to bringing the case. Macca Jr. says, my manager's wife cut Simulu's hair and he wanted the whole place by himself. After each cut, he wanted to see it in the mirror. Took almost an hour. How obnoxious. Mandalore Wise 01 says, all hail being late night degenerate. Yeah, buddy. Not applicable says, I'll beat the brakes off them. .locals.com. Yeah. I'm gonna try and do the beat the brakes off of you instant beef stew. I'll try and do that in the next really soon, and that'll be the link will be on Locals. It'll also be available to YouTube channel members, like always. But we'll do a cooking stream on it. It only takes about 20 minutes to cook, and there's very little prep. It's a real easy dish, but it was really good. And I just invented it tonight, like out of nothing. I had no recipe or anything. I wrote the recipe. Twilight Dragon 3 says, man, it would be funny if America's Got Talent hires Scortus. Greer would lose his mind. Gummy says, you haven't seen Full Metal Jacket? Well, any fucking time, sweetheart. And the way I see it, you owe me for one jelly donut. Why would I owe you for a jelly donut? Jelly donuts are disgusting. J.K. Wynn says Senator Kennedy is pretty good. I heard I like Senator Kennedy in general. He's a sleeper hit because he's a slow talking boy from Louisiana. But I like, he always comes in with the heat out of nowhere, and it's shocking. I'll give it a look. I may do a video on the Merrick Garland thing. And if there's a good clip from Kennedy, I'll throw it in. Bad Vibe says, anyone that wakes up before dawn is a degenerate. This is just facts. Facts. Gummy says, I love working for Uncle Sam. Gummy says, lets me know just who I am. Tyler Weesbrod says, Russell, the situation Greer. V's flat desk Pepsi says, Russell Greer can induce these nuts. These nuts. Let's see. Your mental illness says, why does Russell Greer insist on writing his legal documents like he's a protagonist in a fantasy novel? Because he doesn't understand that the judge doesn't care. The judge just doesn't care. Can't care. That can't be the basis. But he thinks that it's persuasive writing because Russell Greer doesn't have much in his life. But almost guaranteed what Russell Greer does have, he got by exploiting his disability. And you know what? I'm not super opposed to people exploiting their disabilities take you away from stuff, using it to gain sympathy and to get access to different things. I mean, go ahead, right? Like if you're like, oh, I'm a disabled kid. I need to go backstage automatically, or I need to get on the ride first at Disney. I'm not going to complain about that. I don't give a shit. Use it. But he thinks that it'll work in court. It's not going to work in court. Jason McConnell says, Surdix in mini sells Pam Reg with the Parmesan Reggiano with the rind on, Nick. But yeah, I mean, places do, just nowhere around here. That's in Minneapolis. That's 2 hours away. I could get some. I just have to probably order it. Case in point, Crippled Jesus. Funny guy, though. Yes, hilarious. Crippled Jesus got into a strip club in Minneapolis before he was 21, which is very illegal. But, this guy comes in, motorized wheelchair, like, I'm fucking Crippled Jesus. Like, you're going to tell him no? You're going to tell Crippled Jesus no? You can't come in and see some titties flopping around because you're only 20? Fuck that. Let him in. Let him in twice. It was a very unimpressive strip club anyway. DCV Titan. Oh, Russell Wallace Warren says, thank you for your service. You're welcome. DCV Titan says, life is ruined and in a hole. Stop digging then. That's to Russell. Pirate Tomsky says, new Hollywood disclaimer. No cinematographers were harmed in the making of this film. Oh, shit. William Barnes says, you miss 100% shot of the shots you don't take. Kyle. True. But Kyle did miss. He did miss. We praise Kyle because he four Joseph Rosenbaum, one in Anthony Huber, and one in Gage Groskowitz. It's like, oh, damn, 6 shots. But Kyle fired 8 shots and missed 2, which means that Kyle's accuracy is actually down to 75%. 75%. Spigot84 says, hey, Nick, this will make you upset. Vito was interviewed on Newsmax as a free speech lover, and I'm not making this up. It is what it is. It doesn't make me mad anymore. I'm less concerned. Like, okay, a big news company or interviewing Vito and not knowing who he is, that doesn't surprise me at all. I don't think they have time. It's the people in this space who do know who Vito is, who are giving him a pass on everything. That's the shit that bothers me. Nick's Hex says, what's a funnier timeline? Melinda. Oh, and also that Vito hates Newsmax. I mean, but you know, he convinced him to let him on for whatever reason, and they did. He hates news organizations like Newsmax and OANN and InfoWars, but he was happy to, and Tucker Carlson, he's happy to be on those shows. You know, that's whatever. I said my piece on the point where I said that there's no principles on social media. Nick Sack says, what's a funnier timeline? Melinda winning against Josh or Greer versus Moon merely being heard by SCOTUS? If Greer versus Moon got heard by SCOTUS, it would be the funniest thing. It won't happen. James K says, God made Kyle miss the black guy who jump kicked him to punish the media. Oh, could you imagine if Kyle had actually shot the black guy? That actually, like, he'd already be in prison or killed, right? The Cypher Warrior, I addressed that on the video where I talked about it. He would already be, like, the media would have gone to his house with crosses and crucified him personally if he had shot the black guy. The only reason Kyle's not in prison right now is because that black guy's still alive. Pastor Flash says, well, now I'm impressed. Well done, Russell. Vacuous Imago says, please stop this madness. Batgoat says, after seeing the dance, I'm officially hashtag Team Russ. Gummy says, R.L. Stein needs to come out of retirement and write a wonderful Goosebumps book for children about a paralyzed dummy who forces you to judge his claims. Goosebumps is getting a show, like a live action show, like a reboot. I think they used to have a show. It's either got a show or a movie coming out soon. I saw a trailer for it. Also, I watched the full trailer for Cowboy Bebop. Trash. Just trash. But I want to do something. Give me just a second. There's a particular spot in this trailer that needs to be addressed. Just a couple seconds of it. Because it reinforces one of my points. And I'm sticking by it forever. Where is it? Where is it? Where is it? I think it's right around here. Hold on. I'm just finding it and then I'll put it up on screen. Because you can only show a couple seconds of shit like this. Come on. Where is it? Fuck. It's earlier. Come on. Where is it? I know it's super exciting watching me watch something off screen. I think it's Pierrot Lafou. I think it's coming up in just a second. Yeah, here it is. Here it is. Here it comes. Are you fucking ready? Are you ready? It's getting closer. Every time, I'm going to bring this up every time I talk about this fucking movie because I know it's going to happen. See if you can catch it in this clip between Spike and Faye. Are you ready?
Oh, fuck. We're a team.
Did you catch it? Did you catch it? It's closer and closer every time. Every time it's closer and closer. Watch again.
We're a team.
every fucking time. It wasn't the scissor leg takedown. It's coming. It's coming. I promise you this shit is coming. Because it always is. Your mental illness says, Nick, is there any chance you could find out who Greer's Lady of the Night was, then get her on for an interview? I addressed this earlier. I don't think so. I don't think so. I mean, she's been somewhat doxxed, but she, like, this is just a random hoe, right? Professional hoe. But she's a random hoe. She, I believe, was fired from the Bunny Ranch for some crazy shit that happened and disappeared. I mean, again, she's probably snorting crack off of homeless penises in Philadelphia or something. Fractal Machine says, I'm a great entertainer trapped in the body of an unfunny mutant with no musical talents or sense of humor whatsoever, but I identify as a stud. Tomorrow V says, I made a melody for a celebrity. I spent some money. Big disability. Give us some money. Not applicable says, how did an old gay guy have 17 kids with Melinda? I don't know. Zero Voxity says, martial law in the streets. Beta cuck in the sheets. Zero Voxity says, correction, martial law in the streets. Beta cuck with the snack tray. Habita Hubita says, finish yesterday's stream. Can't help but think I grew up in a trailer park and never heard her talk. I'd find her attractive. If I grew up in a trailer park and never heard her talk, I'd find her attractive. Kind of like being from India and liking Jen Psaki. Abadubada says, good old Melissa, that is. Guys, or Melinda. He means Melinda. Melinda has an independent research page where she posts her academic papers on the Torah and some videos about them. I found this today. I found it because I pulled up the link to her video and I can never remember her weird husband's YouTube channel. Like I can never remember. Even now I can't think of the name of it. So I went to her YouTube channel because I had the video still pulled up from yesterday. And I clicked on the about section because you can feature a channel in your about section. And I was like, oh, she's probably featuring Marshall's channel. She's not. She's not featuring any channel, but she has a link to her independent research page. It's on her YouTube channel, and it's got a couple videos and like 19 papers that she has written about Torah. Very insightful, I'm sure. Not applicable says we literally have secret police in Stasi now. Wow. Not applicable says king this man. Bad Vibe says Merrick's peanuts roasting on an open fire. Eka says conflict of interest. His son-in-law. Look for this. Why would you not submit to a simple ethics review? Can't send link here. Kathy Zapp, thank you for the donation. Malik Foxon says if they weren't snakes, they would just say yes or no. Merrick Garland is justified in saying no to some of these questions. I don't know why he thinks it's a big gotcha that he must protect against. Like it's not that big of a deal to say no. No, my memo wasn't actually based on only that. So that part of it, which isn't even in the memo, if they've withdrawn the school board letter, but we still have these other reasonable bases for it, et cetera, et cetera, et cetera. You could just say no, it's okay. Not applicable says he wasn't transgendered, isn't a thing that exists. That was in response to the Loudoun County rapist. No one that I have seen has claimed that the boy in Loudoun County who raped the girl is actually transgender. No news source, no inside information. Nothing has come out claiming that this was someone who identified as a transgender person or anything like that. So YouTube and Twitter have been kind of clamping down. Like YouTube got mad at Crowder about that video and talking about it and stuff like that. But it hasn't actually been asserted that this person is trans. We don't know. And it's not about that's the thing. It was never actually about the trans people. It's about people utilizing the status, either because they are trans, maybe, or because they just want to utilize the freedom of the status to go into a bathroom to cause harm. And you can't question the person in the bathroom. because they're validated in being there under law. And if you question them, that might be intimidation or harassment or a threat based on their protected status, and you could get in some sort of trouble over it. That's the problem. You don't actually know if the person's trans. And guess what? If you're being raped, you don't care if they're trans or not. That's the thing that doesn't matter. But that's the shield also. Well, you just hate trans people. It's like, I don't care about the trans people in the bathroom. I care about the person using this law as a shield to go in and rape someone, whether they're trans or not. That's the problem. Kathy Zapp says prosecutors and cops are more than happy to make your life miserable and insufferable for a long time. If they feel like it, you do nothing about it when innocent. True. There's nothing you can do. TJL says, did Scott Smith make a threat to the school board? Is that what Garland wants to say, but hasn't? I think Scott Smith got excited and agitated when the school board lied to his face and the county around and the other attendees about his daughter being raped. They lied about it. Just in time, briefly on the Cowboy Bebop thing. One of the things I've talked about with Faye Valentine is she mentioned that they couldn't do the yellow hot pants on Faye's outfit. Instead, they went with these like weird leather black pants and full leg stockings, rather than, stay faithful to Faye's outfit. She was talking about because she can't do stunts in tissue paper or some bullshit like that, which is all bogus because women do stunts in very revealing outfits in tons of movies. They could certainly make this work with a Netflix funded budget for costume design. But that being said, it gave me the lingering suspicion that Faye Valentine, who is not known for her combat prowess in the show, she is not a combatant. She is not a fighter. I went, wait a minute. They're going to make this chick do a bunch of stupid woman fighting moves that they've been doing in all of the Marvel shit. All of the Marvel shit has the same regimen of woman fighting moves. And one of them that's coming, because I know it's coming, because they used it in Agents of S.H.I.E.L.D. only 5 billion times, is where the woman jumps at a man because he's big and she's 100 pounds. He's 200 pounds. And she wraps her legs around his waist and she grabs his arm like she's going to do some arm bar or something, even though her legs are around his waist, so that's pointless. And she leans back into a roll and throws the very big man, which is not a thing that happens in real life, but it happens in Marvel movies and shit like that all the time. Constantly. Melinda May and Daisy constantly did this in Agents of S.H.I.E.L.D. I believe Scarlett Johansson did it in Black Widow and probably in every one of the Avengers movies. It is the go-to fucking move. And they're going to have Daniela Pineda do it. And so in that clip, it was not the same throw, right? It's not the same throw that I'm talking about, but it's similar, which leads me, and make no mistake, these people do not understand variety of anything. She is going to be fighting throughout the show all the time, and she's going to do that move at some point. I promise you it's coming. It's just bullshit, and I hate it. So let's, I want to see this. I want to see why Scott Smith is tackled. And I've got the video here. Let's see why he's tackled by police.
Girl and a boy with a boy is wrong. God says men and women are united in one, not men with men or women and women. I also think that transgender is wrong too. You are who you are. You cannot change that.
Ah, the classic. Resisting, right?
She's trying
disrupt things first. Just gonna disrupt things. Just continue on over here. Just continue on.
And that's the mom of the girl saying my child was raped at the school. Let's go. Okay, so we know how he ends up down here, but let's go back to this. Let's take some quick observations on this. Notice we've got a rainbow heart person. We've got a rainbow heart t-shirt. He is not at the podium. So he has presumably raised his issues. So tell me how his behavior is in any relation to a threat of violence to a school board member. I don't know. But look what happens. So they're having a conversation. She gets closer. He gets closer. They're close. Hands are up. Notice who the cops' hands are on. Are there cops over anywhere near her? Are there cops near her? No. This cop puts his hand on this guy's shoulder. And the reason he's tackled is because the cop starts to pull him away and he pulls his shoulder back. Here it comes.
I also think that transgender is wrong too. You are who you are. You cannot change that.
Leave me alone. Nope. Now you get fucking. He gets. It looks like he gets punched in the face right there, doesn't it? Looked like that cop just jacked him right in the fucking mouth. So there you go. I don't see a threat of violence against a school board member. I don't see. It's hard to say. He's not mic'd. Does he have grounds for a lawsuit against cops? Why? For resisting arrest? For resisting arrest like a monster? Let's see this one.
We're going to move to item 5, public comment.
Tuesday's Loudoun County School Board meeting brought lines of people waiting to get inside as parents got to voice their thoughts.
Students, they need the freedoms.
Boring.
Originally put on chin could be seen and brought multiple warnings about crowd reactions until public comments came to an
warnings about crowd reactions.
The meeting brought multiple warnings about crowd reactions until public comments came to an abrupt end and brought an uproar.
I am disgusted by your bigotry.
The motion carries 9-0. Public comment is now ended. We will move to our next agenda item.
That's that First Amendment that's being protected right there at the public meeting.
This cell phone video captures the response as some opponents of the transgender policies called for the ouster of some school board members. Loudoun County deputies later announced the arrest of one man for disorderly conduct and resisting arrest, while another man faced charges for trespassing after refusing to leave. All this took place as supporters from both sides gathered outside.
Here we go. Here we go.
Teachers like
listen to this. Listen to this fucking guy.
Gathered outside the Loudoun County School Board building.
To be able to educate teachers like Mr. Cross and make sure they understand the gravity of what it means to reaffirm our students' identities. That is the goal.
The other side just wants.
I think this might be a different arrest. This is from a while ago. Anyway. Oh, fucking hell. It's just garbage, man. What do we have? Do we have anything from this guy? Hold on, let's check this one.
The push for the transgender agenda in schools has reached new levels of insanity after Scott Smith, a father in Loudoun County, Virginia, was arrested at a school board meeting after getting into a heated exchange concerning the alleged rape of his daughter. Earlier this year, Smith claims his daughter was sexually assaulted by a gender-fluid boy who liked to wear skirts, and when he entered the girls' restroom. Smith and his family have since charged the boy and gathered enough evidence for their case. Smith's attorney said that the boy even incriminated himself in some interviews. The school, however, did nothing about it. Instead, they promoted a transgender protection policy for the upcoming school year, holding a meeting where Smith and other parents plan
can you
to
play the fucking audio?
Later court hearing.
God, these news sources suck. Someone say what he said. Fucking never mind. Someone say what he said. That's what I want to know. What did he say? What did he do? I didn't see much meriting a response, but did you notice disorderly conduct, which is a throwaway charge? Let's be very fucking clear on this. Cops do this all the time. Not all cops are bad, blah, 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 blah. Cops do this all the time. Charge disorderly conduct to justify the resisting arrest. Disorderly conduct will get dropped because you can't prove the disorderly conduct, but you can prove the resisting arrest. Well, the cop just made a mistake on the disorderly conduct. He thought the conduct was disorderly, but maybe it wasn't. Resisting arrest, though, you can't actually make active resistance against an officer. That's illegal. That shit happens all the time. All the time. Okay, anyway. 200 Watt Studio says this whole thing is about silencing dissent from parents. Disgusting. Ironic. Attorney General claims it's to investigate intimidation when they are the intimidators. Not Applicable says, by the way, don't like Cotton too hard. He's a GOP puppet. I don't like any of them too hard. I like when they have good moments, though. That's why they got elected. Those good moments. On your knees, I saw the Hazard Kentucky stuff. Guys, the Hazard Kentucky shit was crazy. Students giving, like, in a public assembly, giving lap dances to faculty at the school. Male students giving mock lap dances. And then female students coming in Hooters costumes and jiggling about and waving and shaking their ass in bikinis and stuff. Very, very not appropriate. Probably for a high school assembly, but the most offensive thing to me was the students doing the like lap dances and shit to the faculty. That like, look, if high school girls are going to dress up in Hooters costumes and dress up like hoes, that's just high school. I went to high school. Girls dressed like hoes and acted like hoes a whole lot. And as a high school boy, you certainly aren't complaining. But if they're not grinding on a teacher or whatever, then yeah. But these boys did a drag show or whatever, and they were literally grinding on teachers, and it was fucking weird and gross. That shit, everybody involved there should be fired and burned at the stake. Crusader Saracen says, hey, Nick, what do you think about kicking kids out of the house at 18? Depends on the kid, depends on the house. Nick Ricada says, ahem hem. In other words, I say, someone from my audience, please show up to my house and dookie on my chest. If you don't, then you don't care about me. Really? Do you? Do you even care? 200 Watt Studio says this AG is clueless as Mueller was at his hearing. The anime guy says the Hunter Biden gun was thrown out by his wife. There you go. That's a nice story, right? Well, I mean, it wasn't me. I didn't leave my thing. Someone else did. If you guys ever get arrested for, negligent care of your firearm and you blame oh yeah, but I had it stored safely, but my wife took it and she left it in her purse. Her purse got thrown away. It was really weird. Just see how that works out for you. Try it. Try that excuse. Try that out. Mandy Caravicka says, what does Governor Jesse Ventura have to say about all these Garland conspiracies?
I think it's pretty obvious from all of the evidence presented that Merrick Garland is actually the reincarnation of John Fitzgerald Kennedy, and he's just looking for Marilyn Monroe to resurrect in a necromancy ceremony with the Archlich Ruth Bader Ginsburg. He's out there working alongside Hunter Biden, trying to collect enough foreskins from the local temple to bring straight to Ruth Bader Ginsburg so they can resurrect Marilyn Monroe so he can choke that bitch out while hitting it from behind and kill her again. This is the obvious ploy that Merrick Garland has engaged himself in, and I think it's shameful that our government is engaged in these acts.
Malik Foxon says dinner is red peppers stuffed with ground beef, mushrooms, onion, spinach, rice, and chopped cashews for crunch. It's not bad. I haven't done them before. Sounds good, man. Cinema Queen, welcome to super lawyer status. 200-watt studio says Garland is a doddering, clueless puppet. Political appointment. I don't know. I just sign memos and say what I'm told. Yes. Yes. That is true. Russell Wallace Warren says Air Force kills Marines. Damn. Nick Ricada says ahem, which is to say that I say the Cinema Queen will be letting me Roman helmet her after the stream. Don't know what that is? Urban Dictionary. I recommend against it. I would recommend against it. 200-watt studio says tomorrow night, Jack Show Halloween special on Cecil's channel. Witten and Nadine guest starring among others. Come for the fun. Watch the streams. 200-watt studio. You can't advertise streams that are happening on my stream. What do you think you have? Free speech to pay for? Paid for speech? 200-watt studio says also on the Jack Show tomorrow, J. Dahl Hefner. Crusader Saracen says Nick will be right about Bebop. He is Nostradamus. Not applicable says hot take that cop should be hanged. Hanged. Not applicable says Cotton got elected because someone wrote a check. That may be true, but he occasionally, on rare circumstances, has a decent take. Okay. Okay. Oh shit. Rees One says, to be fair, the cavalry was believable for being a badass in the show. No, if you have a chick with superpowers, if you have a chick with super extensive training, like, okay, right? First of all, Daisy's superpowers didn't involve any of that. She should have just annihilated. She should have just evaporated people by shaking them seismically. That's funnier to me. But yeah, the cavalry was believable for being the badass in the show. Melinda made it fine. It's not about whether it's about the choreography. It's the fight choreography, right? Like you can't be mad at Wonder Woman for beating up people because it's Wonder Woman. You can't be mad at Supergirl for punching a guy and obliterating him because it's Supergirl. Agent May never always won a fight in the show. Correct. She did not. She didn't lose. She did lose or use the environment. Also, Dad got arrested because another mom basically told Dad she could keep her legs closed. Karens. Yeah, the Melinda May was fine. I like S.H.I.E.L.D. I mean, it has the last season especially got real fucking tiring. But it was an okay show, and the characters are super agents, right? Faye is not. That's the big difference. Faye is not a super fighter, but they're going to make her into one for this show because it's live action and because she doesn't have long legs and big titties, which is all anybody actually wanted out of Faye was long legs and big titties. That's Faye's character. She uses those legs and titties to while her way in. That's the whole way. That's how she infiltrates. That's her rogue trait. That's what she does. But they don't have that. So she's got it. Now she's going to be a fighter. Fucking garbage. Rees One says, Megyn Kelly's channel has the full video. She also interviewed Crowder about it. My theory about Biden, he knows he won't live to face the mob, making sure his Democrat friends will join him in hell. Soon as it's lonely being there without friends, news said trans was bi. There you go. Alex Scott Thompson, leg length is not irrelevant when it comes to Faye Valentine. Ah, damn it. I was going to say a joke about Marshall and I didn't get to because I didn't actually get to review his videos because they're just a copyright bait. Melinda said to me that guile was coming out of my mouth constantly, guile coming out of my mouth. And I just have to ask to Melinda, guile may be coming out of my mouth, but the real question is, why does guile keep coming in Marshall's mouth? Think about it. Bad Vibe says, Air Force doesn't kill Marines. Crayons do. 200-watt studio says, tomorrow at 8 p.m. Pacific time on Cecil's channel, The Jack Show. All right, guys. that's the show. Thank you all for hanging out. We're going to be over on Twitch for a late night movie. God, why do you guys keep making me do these 4-hour streams? We'll see you guys over there. Hope you have a good night. Peace. Peace. Cal Clay says, bet you Faye will have caulk in the show. Girl power. Peace. Peace.